flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We'll open the meeting with a public hearing on proposed law number 1 of 2015. A bit of history here. Whatever you have seen probably up until this day, as far as the revisions are that have been made, are out of date. There's been new revisions, the updated version some of you might not have seen. And it's available here tonight. But due to the fact that the version that was attached to the original seeker and the version that the county planning board saw and the version that the town planning board saw and what is on the table here tonight are two different things. Now this is just the way it came down. So after the public hearing, as I see it, that'll be the end of it for tonight. I don't really think that we can legally vote on something that the majority of the public hasn't seen. It's all there. All the words are there, but the updated version most of you haven't seen. So anyway, we'll start the public hearing. We don't have a sign-up sheet for it, but it's not usually the way we do business. So we're going to give you 3 minutes. Who wants to start? Quentin?
Yep.
Identify yourself, what you do for a living, and how you know quite a bit about what's being discussed here tonight.
My name's Quentin Call. I live at 6372 Main Road, Stafford.
Quentin, stand up.
Okay. And I live in Stafford here, and I have a local business, excavating, trucking, septic tank pumping, things of that nature. And I have a couple of concerns. All right. First off, I commend the committee for all the hard work they've done. There's a lot of things in here. But there's some things I don't understand, and I think it might be as much as not understanding of the legal verbiage more than anything. Right off the get-go in section 182-4, page 2 of 21 of this amendment, I think this is called an amendment. What does that mean in layman's terms, I guess?
Would you say again?
It's page 2 of 21 of the,
Okay.
right at the top it says purpose and intent, and at the bottom I circled A, and it starts out with no building or land. And I was just wondering what does all that mean?
I'm David Slottje. I worked with Kevin Earl, the town's lawyer, to draft this. Since the supervisor pointed me, I guess.
My apologies for not introducing.
No, that's fine. But I would just ask, rather than go, what else, Mr. Call? Had my back turned to you, sir.
Yeah.
What others, just so I can do them all at once?
What other concerns?
Yeah.
On the very next page, B, section C, if you go to the existing zoning law, it says, and the reason these things concern me is because they affect me directly, my business. Let's see, on 182:4, I guess, or -4, applicability, items C says this chapter shall not apply to uses which were legal prior existing non-conforming uses defined herein. And our business has always been a legal pre-existing non-conforming use. We've been here for 61 years in the same place, the same location. I think there's some other businesses in town that also would be construed as.
Did we, well, why don't you go through and give me everything? So that's not a, I'm sorry, there's not, can I just take this and use it as a test? So your second question is not a change, right? You're referring back to the existing.
Well, it is, because on page 3 of 21,
Yeah.
you're changing that, you're doing away with that legal prior existing non-conforming use.
Okay, I'm not, but go ahead, what's your next one? If that doesn't do it, I'll explain that it doesn't do it.
Well, I don't understand the verbiage.
Right, I'm going to explain the verbiage, I just want to get all of them at once, and then I'll go through them, if that's okay with you.
Sure.
What are your other ones?
If you go down to the next line, first off, was most of this predicated about over the gas well business and the gas fracking business? The changes, isn't it? Is that what most of
That was the basis, but
Okay.
there's some
It seems to me like there's other things here besides that that don't mention the word gas well and stuff.
Has your business, in the 61 years, has your business increased over the 61 years? Has it stayed the same?
Oh, no, it's increased.
Okay, so, all right. What else, what are the other things you've got?
Section D, on 3 of 21, accessory buildings.
Yeah,
Some clarification of what that means.
okay.
Most of those all the way down through there's just a lot of changes that, and I don't quite understand why they're changing a lot of them. What exactly they mean, and why on some of them, at the last paragraph, does it say, or any other explicitly prohibited use? It seems like it's all encompassing instead of specific to that particular
Okay.
paragraph.
I understand the question.
Like where it says commercial excavation.
No, I get it, go ahead. I get the question. And, go ahead.
Okay?
Yeah, I get
Okay,
it.
thank you. All right. Where it says commercial excavation, I know you're not saying commercial excavation, I think you're getting around to talking about a gas well, but the very last line on each one of those says any other explicitly prohibited. And if you go to the next page where it says disposal transfer station, any other explicitly prohibited use, and that could be, in my estimation, could be interpreted as all encompassing, and somebody could come back to this law, all right, and say, well, you can't do it because it says everything's prohibited. It seems to be, in my estimation, somewhat controlling or prohibitive, all right? Where you're talking about an injection well, I think I understand what you're getting at with an injection well. You don't want salt and gas fluids going down the wells. But your description here describes a caisson or a drilled pier for a foundation could be interpreted to be one of those, in my estimation, because it says, this is on page 6 of 21, it says, talks about fluids that are injected into the hole, which may or may not include semi-solids, are injected into the subsurface and less than 90% of such fluids return to the surface. I think I know what you're trying to get at. You don't want an injection well, but a caisson is for anybody that doesn't understand what a caisson is, if you have unsuitable ground, in a lot of places in my business, rather than excavate out 15 feet of dirt and put structural fill back in, crushed stone or whatever, gravel, whatever it is, an engineer will design a caisson where you drill down maybe 20 feet until you hit the rock.
Like a pier, sort of?
Yeah, it's a pier, but they pump fluids, they pump a grout into it,
Yeah.
and it returns to the surface, okay? And so, in reality, you could be restricting that use. And we do a lot of those. For instance, John Kennedy School in Batavia was built on those. Homes, actually, not just mobile homes, but some homes maybe don't want a deep foundation or don't want a basement. They might only want to have piers or caissons that they build on, and you're kind of restricting those, I think. In my business, I pump septic tanks. I probably pump half the people in this room. I would expect I pump a lot of people's septic tanks. And we apply the septic to farmland, all right? And I'm permitted through the Town of Stafford. I'm permitted through the New York State DEC. And several places in here, they refer to land application facility and it's prohibited and all that, and it just concerns me that someone could interpret those things to maybe affect my business, okay? And the fact that I've grown shouldn't mean anything. I don't know what you were getting at.
It may or may not mean a lot, but I'll answer that all.
However, you know, we employ a fair amount of people, and these people, a bunch of them live in Stafford, and all of them pay taxes, all of them buy products, buy things from the store over here in Stafford, spend all the money in town, and, you know, it's a viable resource, and, you know, we're very proud of what we built. And I have one employee here that was able to come tonight. But those types of things concern me. The natural gas part, it doesn't concern me. I've been in that business. I've hauled frack water before, fresh water before, in previous years when we were working in the business. So everybody here probably knows that. I'm presently not doing it, okay, but I may in the future, all right? However, I have no objection, you know, the concept I don't necessarily agree with, but I have no objection if this is what they want to do, because New York State already has a law that's been passed that stops it, okay?
It doesn't, but I'll get to that in a minute.
I do question restricting natural gas compression facilities. There is some gas lines and oil lines that run through the town of Stafford, and I'm wondering 10 years down the road if perhaps one of those companies wants to put a compressor station in because they have to up the pressure to get into somebody else's line, or for whatever reason. Things change over time, and if they need to do that, I don't think that should be restricted on. I don't have anything to gain from it. I just looked at that and I thought, what if they want to run a new line? You know, they got a right-of-way that's, say, 100 feet wide. I don't know how wide the right-of-ways are, if they own the property or what. But what if they want to run a new line or replace a line or put a compressor station in? That could be problematic if you're trying to restrict it out, all right? And I don't know that necessarily has a lot to do with the drilling of natural gas right here in the town of Stafford. And in the old days, before horizontal hydraulic fracturing, there was vertical shafts drilled all over western New York. We had one in this town. And I didn't know if you were restricting those. It appears to me you are, all right? Some of those are pretty shallow, okay? And they don't require anywhere near the volume of water that the horizontal shafts do. That horizontal fracturing does, I don't know if they do, I don't think so. Are you saying anything about, on 8 of 21, in the very top paragraph, I see a couple words there that I wondered, waste oil being one of them. Are you going to be restricting waste oil furnaces? Okay, from oil change, you know, where somebody changes oil in the truck bays. I think a few people around here probably have those, all right? I think the brine you're talking about is brine that comes out of a gas well. Is that true? It's not coming out of a brine well? Okay, right. All right, that's fine, all right. I apologize for jumping around.
No, this is.
There's a lot of, I go to page 9, and there again we start up with any other explicitly prohibited uses right after the word land application facility. There's another one down below, explicitly land application facility and other explicitly prohibited use. I'm wondering if one of the farmers around wanted to put in one of these methane digesters. Is that something that they would be able to do because it's agricultural, or would that be restricted as well?
Let's keep going. It would not be restricted under this.
That's a question I'm asking.
Yeah. I'm going to show you why, though, on each one of these.
Okay, good. All right. Can a public utility be putting in gas lines,
What kind of gas line?
natural gas lines, transmission lines?
How do you define a public utility? I'm not trying to play games, that's one of the issues in here. But I'll talk about.
National fuel gas, RG&E,
I'll talk about that.
things of that nature. I mean, they've got lines that run through town here, and every once in a while, a farmer yanks one up with a bull bore plow, which they don't use much anymore, but it's been done in the past, and they've replaced some of them, and then they've installed new ones, and you know, I'm just thinking that this could be construed as the long arm of the law coming down and being somewhat restrictive to business and you know, controlled growth, okay? Oh dear. There's just so many things.
You want to take a break and I get the flavor of this.
Yeah, there's some more in the end, but if you want to.
No, I mean, if you want to keep, I mean, I know what.
There's a lot of them there. The big concern I had was the pre-existing non-conforming use, because basically because you talk about a police state later on here, you know, this is a police act. Is the local policeman going to come down and put a padlock across my door, my driveway, and stop me from driving out, or stopping people from going into the Red Osier, or you know, stopping Murray Call from painting a house, or
Sounds like a safe to me.
yeah, it's just, I don't know. I think the intentions are all good, and maybe you can explain all this away, but clean verbiage like in that first one I read, this to me is very clear. This chapter shall not apply to uses which were legal prior existing non-conforming uses as defined herein.
What page are you saying?
That's on the existing, that's on the existing,
He's in the existing zoning code, nothing that I touched on that area.
well, you changed it.
No, I didn't, I'll explain it in a
Okay.
minute.
Well, go ahead then, let's see.
All right, so let's start with some background here. The assignment was, and the board has not determined that it wants to pass this amendment or anything like it. So I don't want to be speaking for the board. I want to be crystal clear that this board has not come to a decision on this or anything else. But they have asked for a draft of, we have zoning in this town, and they've asked for a draft of a law. Let me back up. They've asked for a draft, which does not mean that they've committed to passing anything like this. But for at least discussion purposes, the board has asked for a draft of a law that would prohibit basically natural gas activities. I'm going to just say that very broadly right now, just by way of background. Our view, and let me say this. Well, I don't need to say that. Our view is that the best way to do that in a town that has zoning is to amend the zoning code. It's not the only way to do it. There are some lawyers who think that you could just do a separate law and said, thou shalt not do any gas drilling activities. I don't like that approach because there is a potential for a conflict between that law that says no gas drilling activities and then whatever happens to be in the town zoning law. Does that make sense so far? So for that reason, we've recommended, and Kevin has agreed, that what we're going to do here is put this amended zoning code. So that's
It's
what's
already been tested in other
right.
municipalities that the
Right.
town does
Yeah.
have the power to do this in
Yeah,
zoning.
well, there's no, it's black letter law that the town has power to do this. In New York State, the highest court is the Court of Appeals. They ruled on June 30th of 2014. There's nothing else to talk about that a town can do this if they want to. Nothing else to talk about. That ship has sailed. That horse has left the barn.
What's that?
That a town has the legal authority
Oh, yeah.
to do this. All right, so our view is that it should be done via a zoning amendment. As a general matter, when you talk about a zoning amendment or a zoning law, it is very important that if there's any ambiguity in the law gets construed against the town and in favor of the person who wants to do the land activity, the permit or whatever. So let me give you an example. When I'm talking about an ambiguity, something that's ambiguous, what I mean is it's something that is susceptible of more than one interpretation. It's not black and white. I'll give you an example. And it's going to tie into public utilities. When people did their zoning codes 30, 40, 50 years ago, they typically said that you could put a public utility facility in any district, residential, industrial, agricultural, whatever it is. When they did that back 30, 40, 50 years ago, most of these people these codes did not define utility or public utility. But what they meant was your local electric company, your gas company that might, I don't think we have gas in this town, but if we did, the town that would run gas lines to somebody's house. Cable, okay, so maybe we do have gas lines.
You don't know, we have a lot of gas lines.
I'm not talking to individual homes?
Tons.
Yeah.
Yes.
Okay, good.
Tons,
Okay,
tons.
good. All right, so that
Everybody
kind of,
turns their gas on every morning and cooks their coffee.
okay, so that kind of. But I'm not talking, well, no, a lot of places out in this part of the state don't have that. They use propane or whatever. So that's fine. Cable and so forth. Those are what most people think of as utilities. They are typically monopolies, and typically, almost always monopolies. And their rates are set by the Public Service Commission, the State Public Service Commission. That's what most people think of when they talk about utility and public utilities. And keep in mind the background, in most places in New York that have zoning, allow people, utilities to situate their facilities in any district, next to schools, next to homes and residential and so forth. What happened recently, relatively recently, in the last couple of years, you talk about compressor stations. I'm not here, it's up to the town board to decide whether they want to prohibit compressor stations. I don't get a vote. I'm not going to express my opinion. You can guess what it is. But I can tell you that nobody I know, and I've been doing this full time for 5.5 years all across the state, I've never met anybody who was happy that they had a compressor station in their neighborhood. I've met town board members who were happy that there were compressor stations in the town because of the tax situation. But I've never seen anybody, whether they were pro-gas, anti-gas, pro-Red Sox, pro-Yankees, whatever their position is on anything, who were glad about compressor stations for a whole bunch of reasons: the noise, the air pollution, and so forth. About 2.5 years ago, somebody came into a southern tier town in a situation that had zoning like this town. It was a privately owned compressor station. It wasn't owned by NYSEG, which is arguably, I mean, they're clearly a utility. The rates are set by the PSC. It was a privately owned gas company. And they forced this southern tier town to allow them to site a compressor station next to a kindergarten, between a kindergarten and a single-family house. And they pointed to the zoning code, and the zoning code said, we can have public utility facilities anywhere we want, in any district. Now, there is no way that a privately owned compressor station was what anybody thought they were talking about when they said you could put public utility facilities in a residential neighborhood.
Question. You seem to be learning on this compressor station.
No, I'm going to talk about everything you talked about.
It's it seems like a bit of a fear-mongering type of a thing that you're going after. I don't know. Because we all have gas, and there are compressor stations, and there are pump stations for water lines in Stafford. There's water towers. There's things, and they're cited pretty well, I think.
Where do we have a compressor station?
So the way
I don't know.
I'm going to jump in until Kevin jumps in. So until Kevin jumps in, I'm going to conduct the meeting until the board takes it back.
Fine, okay.
And what that means,
I'm just asking.
what that means is that there shouldn't be any discussion among audience members. Anything that anybody wants to talk about should be directed to the board. And then if the board decides they want someone else to answer it, like me, then I will. But things should go just to the board and not to each other, please. All right. So what we're trying to do with this zoning amendment is prohibit a very narrow number of activities. I think there are maybe 7 or 8 activities. These explicitly prohibited uses that we're talking about everywhere is a defined term. We use capital E for explicitly, capital P for prohibited, capital U for uses, explicitly prohibited uses. When a lawyer uses a term or deals with a defined term, what that means is that in order to really understand what the law is dealing with, you have to go and look at the definition of that term. You don't want to guess. Sometimes the definition turns out to be intuitive. For example, we've got a defined term here, natural gas extraction activities. That's a defined term. When you go and look at that, it's intuitive. It's what you would guess those extraction activities are. It's basically punching holes in the earth and bringing the fossil fuel out. The explicitly prohibited uses is a defined term, but it's not intuitive. You have to look at them. But there are only 7 of them, which I'm going to talk about in a minute. Basically, with the exception of the compressor stations and the injection wells and underground storage of natural gas, all of the explicitly prohibited uses deal with the waste stream generated by gas activities, either the solid waste stream or the liquid waste stream. And I'll show you how that is when we get here. The reason the number one legal concept in drafting this kind of thing is that ambiguities are construed against the town. So what that means is that we have to make sure that if we want to prohibit the natural gas activities that we're talking about here, if we've got a situation here and we've got do we have industrial districts in this town?
Yes.
So we've got industrial districts as zoning districts. I believe and assume that there's no definition of industry or industrial in our code as written. We use the term dump and dumping. And I believe that we don't define dump and dumping. Commercial excavation. We use the term commercial excavation in multiple places here, but we never define what commercial excavation is. Now let me stay with me, I'm sorry, but this is why I want to do this all at once. I want to come back to this, ambiguities are construed against the town. There's a case not too long ago, a New York State appellate case. In New York State, the lowest court is the Supreme Court. Then you go up to the appellate division, and then you get the Court of Appeals. Long story short, there was a company that actually had, it's called Barracuda Transportation Company. They actually had transportation company in their corporate name. And trucking and transportation companies were prohibited for a prohibited use within the particular town I'm talking about. Distribution center was allowed but not defined. The company named Barracuda Transportation Company came into town and wanted to pull a permit to build a facility. The code enforcement officer said, no, you're a transportation company, and it's crystal clear here. A, it's crystal clear you're a transportation company, it's in your name. And B, it's crystal clear in our statute, in our zoning code, that you can't operate a transportation company here. The lawyer for the transportation company said, we ain't no transportation company, we're a distribution center. And the code enforcement officer said, no, you're not. And the lawyer said, show me the definition. And there was no definition. And what the Supreme Court said, and what the appellate court said, and what every first-year lawyer knows, is that that's an ambiguity. Is that ambiguities are construed against the town. So the town paid paid the same lawyer to do two litigations on that. And there was nothing to talk about. Each court said this is a no-brainer. These people get to say what they're doing is a distribution center. Distribution centers are allowed here. We don't care that transportation company is in the name of the company. Again, Barracuda Transportation Company. And they were allowed to put that distribution center in their town. Even though that's clearly not what the people wanted to happen. Now, most of these situations that you're talking about, that we've talked about, with commercial excavation, dumps and dumping, and I can go through these individually, industrial uses, industry, and so forth. I have not changed anything that's in the code. I haven't tried to say what a dump or dumping is. I haven't tried to say what commercial whatever that is, extraction or excavation is. I haven't tried to say what mineral deposits or natural mineral deposits are. I haven't touched your code on that. All I've done for all of those is I've added something, a sentence, to the end of it. If there was a defined term, I've added a sentence to the end of the definition. And if there wasn't a defined term, then I put in the definition section, but it's not a definition, but I put a sentence in that says, no matter what, we're not telling you what, we're not changing your definition of mineral deposits or natural mineral deposits or commercial excavation or dumps or dumping. All we're saying is that in no event shall the term industry or industrial use or commercial excavation or dump or dumping or anything else be construed to mean, be, include, or authorize any of the explicitly prohibited uses. I know you don't leave that aside what those are for me. So what we're saying is, don't come in here, Barracuda Transportation Company, where transportation company is part of your name. And don't tell us that you're not a transportation company and that you can shoehorn yourself into the definition, in that case, of distribution center. So, we're telling everybody we don't want natural gas waste dumped here or stored here or any of that stuff here, okay? The liquid, the waste stream. And we're going to talk about whether we did that specifically or explicitly enough. We've done this almost 200 times in the state now, so at this point, although you did raise something tonight, I'm going to change an objection law. That hasn't come up before, I'm going to make that change. All we're saying is, don't come in here. We're telling you, yes, you got a law here that says you can't dump this stuff here. But don't come in here with your lawyer. I don't mean to focus on you, you asked the question, but John Doe, whoever's trying to do this. Don't come in here and say, yeah, I know that I can't dump gas waste here under this section of the law. But here, I'm able, I can do mineral mining. Or here I can do dumps and dumping. Or here I can do commercial extraction. And so I'm not really, even though I've got transportation in my name, I'm not a transportation company, I'm a distribution center. All we're doing with each one of these, the minerals, the dump and dumping, the commercial extraction, is we're saying, we're not telling you what it is, we're saying, but what it isn't are these explicitly prohibited uses. Does that make sense?
Some degree.
What part doesn't? Because this is a really important concept.
Well, there's a lot there, okay? So for the
You're right, I shouldn't put you on the spot.
There's a lot there for an individual to read.
What this means is that we are going to say very explicitly what the explicitly prohibited uses are. There are 7 of them. I'm show you.
Could you tell me what those are?
But let me go in order, okay?
Yep.
They're basically the liquid and the solid waste streams, which I'm going to talk about. You're looking like you don't know what the waste stream is. You're in that business, you don't know what the waste stream
I
is?
deal with liquid waste stream, yeah.
I'm talking about from the gas wells,
Okay, all
okay?
right. I deal in liquid waste stream.
I'm sorry, I thought we were talking, so. In this law, explicitly prohibited uses is a defined term. There are 7 of them. 3 of them, and all 7 of those are themselves defined terms. 3 of them are compressor stations, and that's a defined term, and it would be just what you would guess without looking at the defined term. It's underground storage of natural gas, and that's just what you would guess. Injection wells, which you raised a question, an issue I want to address. And then the other 4 have to do with other manners, NNER, disposing of either the solid or the liquid waste stream from gas activities, which I'm going to show you in a minute, okay? So explicitly prohibited uses are very narrow, they're defined terms, and that's what those are. We're going to come back to it in a minute, okay? If you accept, doesn't matter if you accept, forgive me the point. If the board accepts and decides that they want to prohibit these explicitly prohibited uses, either all 7 of them, or 6 or less than 7, or all 7 but with some tweaks, and I'm going to recommend 1 tweak on an injection well in any event, then all this does is say, we're not going to have a situation where somebody can come in here and say, and ignore or thumb their noses at our prohibition of the explicitly prohibited uses by saying, yeah, you've got a provision over here that says that I can't do that spreading over here, but I'm not really doing what you call an explicitly prohibited use. I'm really doing a dump, or I'm really doing commercial excavation, or I'm really doing topsoil mining. All we've done with that one sentence is say, if you, I don't mean it, but if somebody comes in and tries to say that there's an ambiguity, they're going to get slapped down by the court. So that's the conceptual part here. And it's because of the fact that there's this peculiarity with land use law in New York State, that any ambiguity, anything that's less than 100% clear gets construed against the town. You with me? So that's why, you know, we're not doing anything with commercial extraction here. We're not doing anything with dumpster dumping, or excavation, I'm sorry. We're not doing anything with touching mineral deposits and natural minerals. All we're making it clear is that those things do not somehow have, you know, basically be an open window for somebody to come to try to crawl in and try to defeat what we're trying to do by when we prohibit our explicitly prohibited uses. Okay? Now, with respect to the language, if you look at the explicitly prohibited uses, there are 7 of them. We talked before, there's a compressor station, you know what those are. They are underground storage of natural gas, and they're injection wells. The other 4 things are natural gas waste, plural, disposal storage facility. These are defined terms. Natural gas waste, plural, dump. These are all defined terms. Land application facility, that's basically spreading, but of kind of what I think what you're doing with your other waste, but not with natural gas waste. If you look at those, start on page 6, look at P as in Peter, the definition of land application facility. As I'm going to take you through, every single one of these is tied explicitly and limited to the natural gas wastes. The land application facility isn't if you just spread anything on the dirt. It's a site where those natural gas extraction, exploration, or production wastes are applied to the soil. Those are a defined term. If you go over to page 8, middle of the paragraph, and look at the natural gas waste disposal / storage facility definition. Look at little e in the whole, other facilities. Are you there? In any case, used for the storage or treatment of those wastes. So it's not anything except disposing or storage of those wastes. If you go down one more paragraph and look at the definition of the natural gas waste dump, it's the same thing. It's not any kind of dump. It's land upon which those wastes have been deposited or injected or placed or buried. So it may seem like it's quite broad, and I apologize for that. But when you look at these, and I'm sorry that there's so much work involved to look at each one of these definitions, all of those are tied to the definition of natural gas wastes. Now, the supervisor indicated that this is not what county planning saw or what some of you have seen. There's only 3 very, very minor changes. The first 2 changes are on page 8 in the carryover paragraph at the very bottom. And you're not going to have this, so let me give you my copy. up-to-date copy? The board has this, but you guys don't. So, but the only changes, as you're going to see, in our definition of, so what we do with this definition of natural gas wastes is we use that for these waste disposal situations that I just talked about, the land application spreading and so forth. That's what we do with that definition. We have added to, we always excluded, explicitly, expressly excluded from the definition of the natural gas wastes. We always excluded waste generated by agricultural use. But after the workshop session on the 21st, we wanted to make it crystal clear that we were excluding certain things. So we have added, this says, the definition of natural gas and petroleum extraction, exploration, and production waste does not include, one, which is not a change, recognizable and non-recognizable food waste. Two, this is new, liquid human septic tank waste. So this way there can be no question, there's no way anybody ever can say that somehow liquid human septic tank waste falls within the definition of natural gas waste. I personally don't think it ever could have been, but you know, it doesn't matter, we'll kill some more trees, so we go ahead and set, and we're making it crystal clear that it's not. And third, and this is a change, animal manure. So we always excluded and accepted our agricultural waste. But now we've changed that, so it says animal manure, liquid or otherwise, we wanted to pick up as much as we could, or other waste generated by agriculture. So that's not a change. I mean, that is a change from what the rest of the room is looking at. It is not a substantive change, because frankly, liquid human septic tank waste was never covered by this, and in my view, could not possibly be read to cover that. Nor could animal manure, liquid or otherwise. But we are now saying, in case anybody wondered, we're saying explicitly. So that's not a change that county planning is going to be interested in. County planning will tell you, well, of course, we never thought septic tank waste was covered by this.
There were some other ones that were excluded explicitly.
Pardon?
There was some other ones that were, does not include, they were very specific about those, so I think it's a good idea to be very specific about those.
I don't get a vote. The board thought it was a good idea, so that's what we've said.
It's clear.
Good. But my point is, when we talk about whether county, that is not a material or substantive change. It is not a change at all in the sense of a legal change, because those wastes were never covered by this. So we're just saying, we're telling you 6 wastes is Sunday. Now, the only thing that's a real change in here is, let's go back to your notion of pre-existing non-conforming uses. The only thing that this document changes, it doesn't change any of the existing zoning code with respect to pre-existing non-conforming uses. The only thing it does is it adds a new subsection to pre-existing non-conforming uses, a subset of those that have to do with gas wells. So the only thing we've added for non-conforming just deals with non-conforming gas wells. And what we changed specifically after the workshop is, it used to say that in order to be grandfathered, it's the concept here for people, a town can change its laws anytime. It can change what's an allowed use. Let's say that it used to be that there was a 5-story height restriction in town for hotels. Don't ask me why that would be. I'm just making this up anyway. But let's say that the law used to be that hotels in this town could not be more than 5 stories. And let's say that, for whatever reason, the planning board recommends to the town board, and the town board decides to pass a change to the law that says, from this day forward, hotels in this town cannot be more than 3 stories high. Okay? So going forward, if you wanted to pull a permit to build a hotel, the most you could do is 3 stories. But you've got a hotel already that's 5 stories. The town can do two things. They can shut that hotel down, the 5-story hotel, believe it or not, they can do that. But if they do, they have to write a check, because that's a taking of that business, that 5-story business. So nobody ever writes checks. Instead, they use a concept called grandfather. And they say, if you were a pre-existing legal non-conforming use, that's the term, pre-existing legal non-conforming use, as of the time that we pass this law, we're not going to make you tear down your 5-story hotel. And it's still legal, because it was pre-existing. We made it non-conforming with our change. Everybody with me so far? The policy of New York State, not my policy, not Genesee County, not the Town of Stafford. The policy of New York State is that non-conforming uses should be limited, and they should be done away with as soon as possible, if there's any way to do it. And in any event, they should not be expanded. That's the formal policy of New York State, that pre-existing legal non-conforming uses should not be expanded. And normally where you see that, in other words, I've never seen, I've been a practice lecturer, I've been a lawyer since 1981. I have never seen a situation where there wasn't some kind of restriction on a pre-existing lawful non-conforming use provision. Typically they will address things, they'll say you can't expand. You asked why I asked about expanding. Typically they'll say you can't expand if you, okay, I used an area variance situation. Let's say that we didn't want, these are ridiculous examples, but I can't think of better ones. Let's say that we didn't want a convenience store in town. And we pass a law that says no convenience stores, but we've already got a convenience store, and it was legal, pre-existing, non-conforming use. And they're grandfathered. Most places would say, yeah, you're fine with that, go with it. If you burn down, maybe you can, if you're damaged in a fire, maybe you can rebuild to, X% of the cost. Maybe you can build to the same size. Nobody that I know of, anywhere in New York State, and this policy of New York State as a state, is not to allow that convenience store to all of a sudden expand by another 50,000 feet. No matter how many employees they have, no matter where those employees shop, because you're gutting the notion of the pre-existing legal non-conforming use. So there's almost always, this may be an exception in this town, but I've never seen one that didn't limit. They take a snapshot of that legal non-conforming use at the time that the law comes in that made it non-conforming and say you're fine. Maybe we're going to fight about what happens if there's flood damage or a fire. Can you rebuild? Some towns let you rebuild, sometimes don't let you rebuild, sometimes say you can rebuild but only up to 50% of fair market value. And then there are fights about how you compute the value and so forth. I'm going to come back to your use in a minute. Actually, I won't. The only thing, because it's not good for anybody for me to do that right now, but it's in the context of this natural gas situation. The only thing I did with pre-existing non-conforming uses, the original draft, grandfathered. In other words, we're making a change in law, and by grandfathering, we're saying, okay, you don't have to, we're not going to make you shut the thing down altogether. You can grandfather, but you can't expand it. But what we grandfathered were pre-existing legal non-conforming uses. Pre-existing legal non-conforming uses. And the change we made here, so if you had a pre-existing legal gas well, which means not that it had permits, because maybe it was so old that it didn't need permits, but that if permits were required, it had them and they were in compliance. And that's how I've done this clause in almost 200 of these laws for cities, towns, and villages. This one's a little different because what was decided after the meeting on the 21st was we were going to delete the provision about legal. So what we're grandfathering here is pre-existing gas wells. That's it. Not legal. They're non-conforming because of the law we're doing here. We still make sure that they can't expand them. And by the way, there is no law that was passed in New York State prohibiting fracking. On December 17th, and there won't be. On December 17th, there was a cabinet meeting, the governor's cabinet, and the commissioner of the health department and the commissioner of the DEC basically said, and obviously this wouldn't have happened without Cuomo saying it should happen. That's my opinion. Everything's opinion. What they said on December 17th is that sometime in January, I'm speaking now in March, that it's sometime in January of 2015, because this was December 17th, 2014, that the DEC would promulgate regulations via the S-guys that would essentially make unconventional drilling illegal. But there's no legislation. Nobody's passing the law. You'd never get that law passed in Albany. So it's going to be a regulation, it's not a law. And it was supposed to be done in January, and it hasn't been done, it's March. So I don't disagree. They're not going to allow fracking, but there ain't no law, and there's not going to be a law. If they do what they said they're going to do on December 17th, it will be a regulatory band-aid. And the reason that towns like this are considering doing this, even though they announced it on December 17th, is because with the next DEC commissioner, with the wave of a pen, whatever supposedly is going to happen in January that didn't, could go away. Is that going to happen while Cuomo is in charge? No. Can anybody see Cuomo going anywhere with Hillary going to D.C.? No. And nobody saw Spitzer going away either. So I'm not saying you should do this kind of law. I happen to think you should, or I wouldn't be doing this. But if you're interested in doing this, you being the town board of the citizens, you do it because you cannot, should not take any comfort from that announcement on December 17th. It's going to be a regulatory fix, if anything, and so far they haven't even done that. But no, there's been no law. There's not going to be a law. Nobody thinks there's going to be a law. There's going to be a regulatory policy.
It's not even clear what they're going to
Right.
regulate.
Right.
Whereas here we're defining the 9 and the 7 thing.
Right. And by the way, the pro-gas people in the state, and there are quite a few of them, Kevin's comment reminds me of this, they have sworn, they pricked, their fingers with blood and, promised each other that they're going to sue to overturn whatever this thing looks like on December 17th. They can't sue. They can't even tell what they're going to sue about because, as Kevin pointed out, nobody knows what their target is yet. But many of the people who are saying don't pass laws like this, you don't need them anymore because of what they did in Albany, those same people are basically blood sworn to, as soon as they see what the thing looks like, to try and turn it over. I'm not suggesting you're one of those, but I'm just saying you can't, one should not rely on that announcement on December 17th. So there are only 3 changes that this room hasn't seen. 2 of them are to specifically say that the definition of natural gas waste does not encompass liquid human septic tank waste. It never did, so that's not a change at all. Or to say that the definition of natural gas waste does not encompass animal manure, liquid or otherwise, which it never did. So that's not a change at all. The only change is to change, we had grandfathered pre-existing non-conforming legal wells, which I guess is only one anyway, but we're now striking legal. So we're grandfathering pre-existing wells. But whether they were legal or not, they can't be expanded because it's a policy of New York State that non-conforming uses are not supposed to be expanded. That's black letter law in New York State. Okay?
Question. What's the definition of expanded? Can they clean it? Can they swab it? Can they maintain it?
These guys, yeah. Are you talking about the wells?
The town here.
Yeah, this is basically.
They got a well and it hasn't bothered anybody in 30 years.
Yeah, yeah. If it's produced, it's got to be produced. If they just got a hole in their backyard, like a lot of these people do, that's not going to be grandfathered. There's tons of uncapped wells. And you wouldn't want that. You wouldn't want those uncapped wells somehow grandfathered. You don't even know about them. The DC doesn't know about it. That's the problem. Let's see. So, I've gone to great, you talked about utilities, public utilities. Our code uses the term utility, public utility facility, private utility. I have made it clear with the definition, I've changed the definition of public utility to make it clear that it's got to be, it's not a private situation. It's a monopoly whose rates are set by the PSC. So the people who are pumping gas into your house, you can turn on the stove, those rates are set by the PSC, you're fine. But what we don't want here, at least in this draft, unless the board says otherwise, we don't want somebody to come in here who's not a PSC regulated utility, a privately owned compressor station, like they did in the southern tier, and put it next to somebody's kindergarten or home. And so all we're doing here, I'm not changing what your definition of private utility is. I'm just saying, listen, you do whatever you want with a private utility, but you can't have a compressor station or any other explicitly prohibited use. Understand?
I think that some of the varied lines here are private. I think Sunoco's got a line. I think the gas line running down through goes to that plant in Batavia by the milk plant.
Well, first of all, they're going to be grandfathered anyway. Let me say one other thing. Usually compressor stations are part and parcel of a pipeline. If the pipeline that the compressor station is part and parcel of is a big one, then we can't do anything, no matter what we say here. We have no authority, the town has no authority, only the feds, the Federal Energy Regulatory Commission, FERC. If it's a middle-sized one, then the town has no authority, only the state does, the public PSC, Public Service Commission. Only the small ones. But if the Sunoco line we're talking about doesn't fit within one of those, it's part of a pipeline that is not, and also we did not prohibit pipelines in here. So, I was going to say, if Sunoco's got a pipeline and it's not a FERC, their pipeline is not subject to FERC and it's not subject to PSC, and they need to put a compressor station in, they're going to have to put it in a different town if this law gets drafted the way it is. I was going to say it's a taking, but it's not a taking, because they don't have a compressor station here, and we're not stopping their pipelines. If we were prohibiting their pipelines, that would be different.
Might never happen, I thought of it.
If it does happen, I have no interest in protecting Sunoco. We got plenty of orders. Let's see. So, it's me, it's not you. I feel like we're breaking up. But on the non-conforming use stuff, I understand why, that's dense stuff, and I understand why that. But what I'm telling you, Kevin's here, and I can take you through it word by word, either in the group or outside the group. If you look at B on page 12, notwithstanding all of that, the only thing, we don't change anything in the existing, pre-existing non-conforming use section of the zoning code. The only thing we do is we add a new subclause D, as in David. And that D just addresses the grandfathering of pre-existing gas wells. So whatever else you've got in there, which I assume, since I've got a D, is A through C. We haven't touched any of those, except to preface each one of them with the words subject to the succeeding paragraph D. So the only changes we made in the existing provisions of the code with respect to non-conforming uses is to say subject to paragraph D in each one of those. And paragraph D deals with one thing and one thing only, and that's pre-existing gas wells. And again, for those of you who might be disappointed because we're working from a draft you haven't seen, the only difference between what I'm holding and what this gentleman is holding and what the board is holding and what you've seen is we used to grandfather pre-existing legal gas wells, and we struck the word legal. So now we're grandfathering pre-existing wells. And they're not grandfathered, unlike some businesses in town, they're not grandfathered, and they can do whatever they want forever. It's a snapshot. That's what you typically do with a grandfather situation. and they're not allowed to expand. They can't turn into a fracked well, they can't expand, go to a different horizon, they can't increase or change the well bore, they can't do anything. And that's what's typically done with grandfathered uses. Okay? So, when we look at the definition of land application facility, go back, that is basically spreading, which I understand from what you said why it worked, but when you look at the definition, it's spreading of those wastes, which is a defined term. Whatever else gets spread, none of our business. Doesn't make it legal, but this doesn't make it illegal. We're not touching that sort of thing. So all of these things that are these explicitly prohibited uses that term is a defined term. Each one of those contains defined terms, and all of those with the waste streams are specifically, explicitly tied to the wastes. Now, I have not heard, nobody's raised before on the injection well. I do think, I'm not suggesting that we take comfort from this, I do think an injection well is sort of a term of art, but I'm going to make that change, and I appreciate you bringing it to me. It can only strengthen it. So I'm going to make that clear that that's, casings and structural piers and things like that. I mean, better safe than sorry. And by the way, this, what I said before about the ambiguities construed against the town, if the town ever tried to use this law to prohibit structural piers, I'm sure they would lose. But I'll put that in anyway. So thank you for that. You asked about waste oil. If you go to page 8, the top, the carryover paragraph, D as in David, any chemical waste oil, blah, 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 that was used or produced in the drilling, development, transportation, and refining of natural gas. So everything is tied to, you might have to, it's too much reading, and I apologize for that.
Well, for 3 changes, which are 27 pages.
Well, you're getting a red line version of the whole thing. The only things that are changed here, if you can, sorry folks, but just so you know what you're looking at. The only things that are changed are the things that have the lines
Here, this one.
Yeah. So there really aren't a few changes. And there was 2 typos. Let me think. Police is police state. I don't use the word police state.
Well, police something or other.
Police power
Yeah.
is that sounds terrible. It sounds like people hitting us with batons in Chicago in '68. That's not what it is. Police power is just a source of authority for the action that the town board might take should they decide to pass this law. It has nothing to do with, people with riot sticks or.
Section E on page 14 at the bottom there. This is the only law, the following text. Proposed plan, unit development. What does all that mean?
So we have a, sorry, what page?
At the bottom of page 14.
I think we're looking at different pages, but I know what it is anyway. So we have a concept here called PUDs, or planned unit developments. And basically, I don't know how it works here, I don't carry the zoning code in my head, but the way it works in most places, if you've got a particular type of use and you are of a certain size, it's typically 5 acres, but there's no magic, it's essentially a way that you can get your property rezoned without it being spot zoning, which I'm not going to go into unless you want me to. But it's a way that people can get around spot zoning. They build it into their zoning code, and they basically say, notwithstanding everything else we told you that you can't do anything, unless there's a use that's articulated, it's allowed. If you've got, in most places, if you've got a PUD, a planned unit development concept, you can come to the plan, usually it's the planning board. I've got 5 acres, I want to do this with it, and then it's a rezoning that isn't spot zoning. All I did with that, even though I can't find it here, but I know what I did with it, is I added a sentence that said, do whatever you want, but using the PUD procedure or otherwise, but basically what it says, you may not use the PUD procedure to backdoor us and basically do an explicitly prohibited use. So what we're saying is do whatever you want with the PUD, but you may never use the PUD to get authorization to do an explicitly prohibited use,
Which are, built again.
which are those 7 things. Yeah, I'm sorry, that's page 15 on my part, but that is exactly what it just said. And you'll also notice that we had, this is not a change, but we have always said, I don't know what, probably your page either 14 or 15, it's paragraph C, no application to customary local distribution lines. Do you see wherever that is? The prohibition, so this is basically all these explicitly prohibited uses. These are not intended and shall not be construed to, the first thing doesn't have anything to do with us. 2, prevent or prohibit the transmission of natural gas through utility pipes, lines, or similar appurtenances for the limited purpose of supplying natural gas to residents of or buildings located in the town. So there is no way, we wouldn't have picked it up anyway, but this is one where we specifically, explicitly said, come heck or high water, okay? Did you ask anything that I didn't address?
There's some comments that are just comments, and I don't think we need to, that's okay. I keep going back to it was pretty simple, the pre-existing legal non-conforming use.
It's the same.
Article C.
As pertains to you, it's the same. The only,
Can you put that back, can you put that line back?
I haven't touched it.
Well, it's gone, it's gone.
I didn't touch it. The only thing that I've done to the pre-existing use provision, you've got 3 things, A, B, I assume, since I'm working with D, there must be an A, B, and C. And all I did was add to the beginning, the first paragraph, the first sentence of A, B, and C, the phrase subject to paragraph D below. So that's the only change I made to the existing code, and I added section D. And section D only deals with the pre-existing gas line. Right, I've got the existing code.
It says, delete it in its entirety. So you're kind of deleting that. That's the one that keeps coming back to my business.
Do you have a page by any chance?
182:4.
That's the existing code?
Yes.
What are we looking at in the amendment?
3 of 21, right at the top, C. Well,
Okay, 182 what?
bold C with the small, or bold B with the small.
182.4?
182:4. Yeah. Is that how you say it? Colon?
Yep. Unless your name is Colin Powell.
That's got that.
Let's see. Sorry, we're working from different. Kevin, that's not what I want. Are we looking at the same thing?
It says there. Take it up here.
3.
Here.
That's what it's, that doesn't have to do with grants. I'm sorry, everyone. What are you looking at?
Okay, this is the existing one. Right here.
Yep, I know that. What are you looking at?
Amendment is the same thing. It says, delete the present text, the local law shall not apply in its entirety, substitute. And that explanation doesn't say that.
Yeah, that's the problem. Thank you.
But it's in the 182 here. It's in 182-4 right there. It's in 182-4. Applicability. A, B, C, right there. 2-4. There.
But, yeah, but that's not, that doesn't have anything to do with what you're doing.
Right there.
But that's not pre-existing usage. Right, but that's not pre-existing use, definitely, section.
It says,
All right, so let's, okay.
it says it right there.
Right.
It says that I don't have to adhere to all these.
Ann. I didn't hear it. I'm not saying that's above that. Okay, all right, I see your point.
See what I'm saying?
Yeah, you don't need to worry, because this is what really does it, but I see why you're raising it.
Please put it back.
Well, I don't want to put it back in.
Don't need to
That's what I
reverse.
wanted to do. But we,
Somehow we gotta protect.
well, you're protected in this part, but
Where is it?
page 12, B is in boy.
Of the new one?
Yes. It's going to take you a while to read this, but the first part was just changing the title. It used to say non-conforming uses. Now we're saying non-conforming uses are non-conforming gas wells. Then 2 in the hole, 3 in the hole, just as what I said, which is just makes everything subject. So you basically are getting flipped back to 14. 182.14.
There's a few, you said earlier, if I didn't want to expand it, I can't expand.
That's not for me to say. I didn't say that
It's
at
got a
all.
long gradual expansion and it'll probably, you know, you got enough room back there if I
So-
wanted to have a
So
building.
I said a couple of minutes ago that probably we don't want to talk about this right now. I don't want to be presumptuous. I don't think it would be good for you to talk about it.
I have no intention of it right now, but
Then let's not,
20 years, you know.
that's, yeah. You know, they can deal with this or we can deal with it now, but I am telling you, it's the policy of New York State that pre-existing legal non-conforming uses are not supposed, A, are not supposed to be expanded, and B, the non-conformity is supposed to go the other direction. So that's why I'm saying we don't want to talk about it from.
Um,
This isn't changing that. Whatever the law
Right,
is
right,
now,
right.
this is not changing.
Yeah, we don't touch that. Right.
Do we risk, I'm asking a defining question here. Do we risk by trying to define it too tightly in here that we could be subject to having our law challenged? Specifically using the New York State prohibition on expanding legal non-conforming conditions.
If we were defining it tightly, yes, but we're not touching it.
No, that's what I mean, that's why it's not touched.
So we're not creating any risk to anybody.
And that's why you don't want to throw a provision in trying to tighten it, because you're going against.
Right. Yeah, I'm not touching anything.
You're going against the prevailing law.
Yeah, I
So,
can look this gentleman in the eye and say that I have not touched your business with this language. You're non-conforming. All I've done is I've added a new paragraph D, which deals with, A, B, and C now say subject to, just to make it crystal. I don't want anybody who's dealing with gas wells on my stuff on D, which is what I put in, to point to A, B, and C. I don't even remember what they said. Maybe they say you can expand, or maybe they don't say you cannot expand. Sounds like that's the case, and that's how you got reworked.
I thought you were going that way.
Yeah, so I don't want anybody, I'm real happy with my D, or it was before we, but I know what D does. I don't want somebody to come in and point at whatever it is you're relying on in A, B, and C, and say, based on that, you can expand this gas well down here. So all I've done to A, B, and C is say, subject to paragraph D. So no matter what it says, I'm not changing what it says, but I'm saying in the narrow, limited situation of gas wells, you look at D and not A, B, and C. That's all I've done. I haven't touched your business otherwise.
So, in your estimation, any legal pre-existing non-conforming use in the town of Stafford will be able to continue their business as they are right now?
I do not, give me 1 second, I do not carry Stafford's pre-existing legal non-conforming use section in my head. But if you give me 30 seconds, I'll look at it.
Well,
and
it's
make
just
sure.
not changing it. The idea is it's not changing it.
Yeah.
He's not changing that. Whether or not it's legal or not legal, we can't say tonight. We can't say what expansion is allowed. All we're saying is whatever expansion is allowed or whatever is legal or not, for anything other than these things stays the same.
Let me give you one example. You've got a section here, it doesn't matter what it is, but it's C4 in the whole of 182.14. It says a non-conforming building may not be reconstructed or structurally altered during its life to an extent exceeding in aggregate cost 50% of the assessed value. So forget your business, because I don't want to. In my hypothetical, my hotel, this basically says, whether it burns down or whatever it is, if it's going to cost more than 50% for me to fix it, then I can't fix it. I don't want to be in a situation where somebody basically, I've done my section D, I said you can't expand natural gas wells. Their grandfather, I don't want them to be able to come in, and I'm happy with what my language D says. I don't want somebody to be able to pick to point C4, remembering that there's an ambiguity, that if it can be read one of two ways, it always goes in favor of the land applicant and not the town.
So you're adding that, you can't?
So what I've done, I've added to paragraph A, to paragraph B, to paragraph C, I say subject to paragraph D, which is my gas well stuff. So what that means is this part C4 that talks about the 50%, that does not apply to gas wells. By saying subject to paragraph D.
Didn't we talk about, did you guys try this a year or two ago? Doing something with changing from 50% increase in the size of the building?
That's a different issue. That's a planning board issue. That's not what we're doing here tonight. I'm giving you an example why I brought it up to explain to you why A, B, and C, each one of them says subject to paragraph D. Because I know D, because D says the gas wells are going to be grandfathered the way I say they are here in D. And I'm comfortable with that. I don't want somebody, and we all know what that means, I don't want somebody to come in here with Barracuda Transportation in their name, say they're not a transportation company and they're a distribution center. I don't want them to use that analysis and be able to say, hey, I don't care what D says, C says that as long as I can spend up to 50% to redo this. I don't want them to be able to spend anything to redo it. The gas well. I'm only talking about the gas wells. Because the only way, because what's going to happen here is, because these are people, I'll say it, these are people who apparently think the law doesn't apply to them, since they didn't bother to get a DEC permit, and it's hypothetical. So the last thing I want is these people to come in here and try to start fracking when there's a change in administration and ignore paragraph D of going to C4. I don't care what you do in your business, I don't care what farmers do in their business, but I don't want somebody to be able to come in and do an end run on what I did here with an ambiguity. So anywhere that I see a possible ambiguity, when we're talking about public utilities, commercial excavation, dumps, I'm going to say come hell or high water. I'm not saying what it is, I'm not saying what you do with it, but come hell or high water, you can't do explicitly prohibited uses. So the only thing I'm touching, the only thing, Kevin, presumably trust Kevin, you know who he is. The only thing we're doing to the non-conforming uses here is adding a new section, D, that deals with gas wells, and we're prefacing each of the existing sections, A, B, and C, with the words subject to D, to make it clear that A, B, and C do not apply to gas wells. Gas wells get treated separately. Does that make sense?
I know a transportation facility needs trucks.
What, I don't know, what's that?
Well, you said the transportation facility, I know they need trucks, but I'm just, that's...
The reason that this is so long is that over time, towns came up with laws and said things like you can't have a transportation company in this section of town or in town at all. And companies come in, and companies that have the word transportation company in their name come in and say, I'm not a transportation company, even though it's in my name, even though I have plenty of trucks. I'm really a distribution center. So you've got two parts of your code. The code over here says no transportation companies, and this code, and this same code, same town, says distribution centers are okay. Forget how we got there. This is a case. This happened. So the transportation company, which apparently thought it was a transportation company, given that they put those words in its name, came in and said, we ain't no transportation company. We're a distribution center. And the poor town had to pay a lawyer twice, at the trial court level and the appellate court. And the court said, everybody knows if there's any ambiguity, if you can read things more than one way, you always let the landowner do it. So that town, which thought they did a good job prohibiting transportation, would you want to? No, I like transportation companies, I don't care. Just giving you, that was the case. All I want, so what I've gone through is everywhere here where I could even guess that someday, somewhere, somebody would say, I'm not really a natural gas well, I'm doing commercial excavation, or I'm doing topsoil soil mining, or I'm doing a land dump. I'm not, don't tell me I can't dump these waste chemicals because I'm allowed to do a dump over here. I'm not changing what you're allowed to do, except I'm saying, make sure you understand that you cannot do an explicitly prohibited use. That's what this whole thing does, and it's the only thing it does. I've not taken away anything that anybody had before, other than the natural gas activities, which may or may not get, you know, go ahead.
Yeah, I heard a comment that says, well, we have a dump and dumping law, why do we need this? Well, you haven't changed the dump and dumping law. You just need this to say, whatever that dump and dumping law says, you can still do, but you can't do this.
Right.
Okay, so he's not changing it, he's just making sure that, you know, it stays the same, but don't let anybody try and come back and say, we're a dump and dumping law. So we're not changing the dumping law.
We don't want somebody who's coming in with, let's say solid waste, you know, like, it doesn't matter, some kind of waste stream. And the person looks at the law and they say, yes, I understand that that's one of the 7 explicitly prohibited uses, and that's not allowed here. But the way the law works is that even if that's clear and the person understands that, if there's another provision called dumps and dumping or whatever, the person can come in, it doesn't matter that they saw this, they knew about it, this is where I'm coming with that transportation company distribution center case. The person can say, yeah, I see it over here, but I'm also a dump, or a dump, and so this isn't allowed use here. Even if the town wins on appeal, they got to pay him. They got to pay him on appeal. You know, he only needs so much money for his greens fees. Do you see? Nothing's being taken away except the right to put gas industry waste stream in Stafford. Which, by the way, in case people don't have an opinion on that, Pennsylvania lets the drilling companies do almost anything they want. They've got pretty much a blank check in Pennsylvania. The one thing they can't do in Pennsylvania, they can't dispose of Pennsylvania-generated waste, liquid or solid, in Pennsylvania. Think about that. They let them do anything. But once they pull this goop out from 3,000 feet below, 5,000, which is radioactive and everything else, even Pennsylvania says you can't dispose of it in Pennsylvania. You can't even put it in the same property that you took it from. Once it comes out of the earth, that's how bad it is. So all we're saying, if the town decides they want to do this, is you can't bring it to Stafford here. And if you've got a problem with that, ask yourselves, why is it? That's the single biggest expense stream for the gas industry. Why do you think they're shipping it to dumps in New York, injection wells in Ohio? If they didn't have to do it, they can just leave it in Pennsylvania. They can't leave it in Pennsylvania. That's how bad this stuff is. I guess I showed my opinion on that. Any other questions? Okay. Thank you.
Anyone care to speak on the subject? Anyone have other opinions?
It feels good to stand. I'd like to introduce myself. Everybody who doesn't know me, my name is Jim Southall. I've been a Town of Stafford resident for 61 years. Live over at Godfrey Pond and have for all that time. I've been on the executive board of directors over there for 58 of those years. Currently still on the executive board of directors. and chairman of major conservation programs. Club obviously is very interested in conserving its natural resources and protecting that item is foremost among what our concerns are. Got a letter here based on all that's been going on. It's addressed to the Stafford Town Board from the association, from me as spokesman. Stafford Town Board, March 9th, 2015. It was 3 years and 1 day ago that our organization drafted a letter to the town board requesting a moratorium on hydrofracking before it became known as natural gas exploration and drilling. Later that fall, in response to our request and the request of others, a moratorium was passed and a study committee formed. As you know, the committee didn't finish its work, and the second moratorium was passed in March of 2014 with the goal given to the committee to make proposals to change the town zoning laws to correct voids that leave our town unprotected. Instead of the committee attempting to write zoning laws, an attorney, Mr. David Slottje, we've heard from for the last hour and a half, was sought out and after a very informative presentation to an open town meeting was selected by the town board to review our zoning laws and make recommendations. His work is pro bono and he's considered one of our and he, in consultation with our town attorney, accomplished this task. Mr. Slottje is well known throughout the state for his work on environmental and industrial law, and either wrote or participated in the writing of zoning changes, bans, or moratoriums for nearly 200 towns throughout the state. There have been 2 major lawsuits brought contesting these zoning laws in the towns of Dryden and Menfield, and the towns won in the hearings up through the New York State highest court. While we recognize that drilling operations are unlikely to occur in Stafford, the real danger to us is in the disposal of drill cuttings and flowback material from hydrofracked well sites in Pennsylvania. These contain levels of carcinogens, heavy metals, methane gas, and are often radioactive. If the pages will come apart. Pennsylvania has seen fit to resolve their problem by banning the disposal of the cuttings and flowback water onto the state of Pennsylvania lands, thus mandating their transport to other states. Unfortunately, our DEC hasn't completely studied the problem with the material that Pennsylvania has had and currently allows them to be disposed of in New York State. There is little or no testing of hydrofracking materials entering the state. These potential dangerous materials are currently spread on some roads, deposited in some landfills, spread on vacant fields or farmlands, processed through some waste management facilities, or inserted into abandoned wells. The proposed zoning changes would protect the property, health, safety, and well-being of the town of Stafford, the residents, and should be enacted as quickly as possible. The current moratorium expires this month. There is no reason for further delay, as the process has been dragged out for too long. The Town of Stafford Board unanimously voted for both moratoriums and to send the zoning changes to the County Planning Board and the Town of Stafford Planning Board. Representatives of our organization attended both the County and Town Planning Board meetings, and in both cases, the zoning additions, modifications were approved unanimously with minor changes. We therefore encourage you to vote on these proposed changes to the zoning laws and to allow the town to be in compliance with its own comprehensive plan. We appreciate your efforts in this critical matter over the past 3 years and trust that you'll do the right thing. You've been the leader in this effort in our area, and we're sure that other towns will follow your example. It should be stated that our organization has been incorporated since 1909 and has been twice recognized as the Outstanding Conservation Club in New York State. Be it herewith known that this is the position and the desire of our organization, wholly located in the town of Stafford, and containing 1,445 family memberships, covering approximately 3,000 people. We take this issue very seriously and will work with the town in any way desired to fulfill this end. Respectfully submitted, this is by the Genesee County Fish and Game. Got a couple other comments to make. I attended both County Planning Board and the Town Planning Board meetings. The County Planning Board passed it unanimously with no comment. The Town Planning Board talked about the gas well situation that has been subsequently changed. That was Mr. Van Olf's only concern at the town planning board meeting. When we voted on it, they said that that was one concern that they had that they wanted changed, and it was also passed unanimously. I think that the outline 3 changes that were made, everybody in this room is aware of now. It's not a big thing, and it's way past time that we take action and get this done. I think it's been dragged out long enough. Thank you.
Yes.
Yeah, can they put that for the record, the copy of the letter?
You can have that. Have the gentleman of that.
I'd just like to call your attention, at the memorial service for Richard Call in August, they had a luncheon afterwards, and during that luncheon there was well, I call them slides, the digital equivalent of slides, and one of them was a picture of Mr. and Mrs. Call and Senator D'Amato. And Mr. and Mrs. Call were apparently quite pleased by the expressions on their face to be pictured with Senator D'Amato, but the senator was not quite so pleased, apparently, by the look on his face. And I just call to your attention this book. It's an unauthorized biography of Senator D'Amato, and the 42nd chapter in it details some of his organized crime connections. And I have here a copy of called The Social Network Concept of the Gillibrand D'Amato Influence Machine. Apparently Senator Kristen Gillibrand is sort of a...
How is all of this relevant?
Well, I'm thinking that what we need to do here is really do everything we can to try to protect our environment, because political things, organized crime influences the legislature, and they, that happened it happened to follow very closely when Monroe County cited its Mill Seat landfill, and I found that the State Environmental Board, which has to approve any change in DEC's regulations, the chairman of that environmental board was a DEC commissioner at that time, Thomas Joyling. The vice chair was at that time Dr. David Axelrod, who was the commissioner of health, and they approved a change to the definition of aquifer that facilitated the citing of that, and it made no sense. There was no protection. And our county water project, there was no mention in the Environmental Community Assistance Consortium WCAC report produced by Cornell Cooperative Extension at that time, dealing with toxic substances in Great Lake water, well, toxic substances at all. So that's just a cautionary tale, and it's peripheral, but I'd be happy to make this available perhaps to this attorney. He seems he might be interested there. There's a link to the website where I found that.
I know about the motto. Thank you.
Pardon?
I
Can
know
I
about
paraphrase, or are you just trying to say, in other words, basically what we said, don't trust the state?
Well, that's basically it.
In other words, you don't trust the state to...
And I think maybe we're of a like mind. So anyway,
Thank you.
I felt I had an obligation to say that.
I'm Lester Bond, I'm the zoning and code enforcer of Town of Stafford. I like the idea that you're looking at the ban the fracking, and looking at the dumping of the chemicals back here in town, whether it's in our town or from some other town. The thing that kind of puzzles me is why are we changing the accessory use? Now, I'm directing this only at the town board, nobody else, but I just don't get it through me why we're going to try to change all this accessory use building and everything that goes with it. I understand the ban fracking. Good idea to do it. But let's not be getting into everything else. We're trying to railroad something else onto our ban fracking. Just like the state likes to railroad stuff in on the back of a bill. We're doing the same damn thing. That's what we're trying to do. We're going to do this, we might as well bring some other stuff in on this.
Okay.
Okay, thank you. Thank you, Board, for recognizing me. My name's Dick Cotton. I've been on the Board of Directors and a member of Godfrey's Pond ever since I was a junior. If you stay on the board long enough, you get to be the old buzzard. So I guess I'm the old buzzard. Now, what do I know about gas or fracking? For 80 years, 3 of them I probably didn't know. I've been going to an area of Pennsylvania where my mother's from, who's 103. This particular area of Pennsylvania is right now, to use a metaphor, is smack dab in the center of this fracking area. They sold the farm in Pennsylvania, and Mom and Dad bought a piece of land so they could go there and visit the family. To make a long story short, I own this property. I now have 4 frac wells within 1/8 of a mile of me. There are 9 in the area. For the last 6 years, I don't want to belabor what happened to that community, but it's unbelievable. Now the fracking is over. And talk about the pressure wells and the booster wells and all that are now making noise over the valley. This is a pristine area down there where you could go off the beaten path, and the same names are on the mailbox since mail delivery started. But this is not what my subject is. My subject, I also own land in the southern tier that has 3 gas wells on it, dug the old-fashioned way. My concern is really for Godfrey's Pond. We get our water basically from Horseshoe Lake and Seven Springs, makes its way down through the swamp and the lowlands there, goes into Pro Road extension, under that quaint old stone bridge, which you can't see because of the brush, and through the lowlands down along through the farmland till it comes to our property. If you drive your car up on Mill Road and look westerly, you'll see that the glacier has produced a bowl effect. When you go from the community college, basically, to that aquifer, it's like a big bowl. Approximately, well, Jim says, the railroad, they needed water for the old steam engines, so they dammed up what is now Godfrey's Pond. So now we have approximately 40 acres of water, which we're very, very concerned about, because that aquifer, as Bigelow Creek goes through Pro Road, down there a little ways picks up what we used to call Thornell's Brook, which is a happy little brook stream of spring water that emits from and back to the trailer park, finally makes its way to Godfrey Pond, and whatever is spread on that road and on the farmland and the aquifer in that area ends up in our bowl of water. So because we have swimming and we also have drinking water from a spring, we're compelled to pass the health department tests for our water quality and also our potable water. And we also have a very active, successful trout rearing program, and anybody that knows about trout knows they need the quality of water to survive. So we're very concerned about the quality of water that's coming into our area, and as it leaves our area, it goes through the farmland down below, where the landowners down there use it for irrigation purposes. Now, fracking produces a wastewater that is very, very toxic. I'm not a chemist, but I know one thing. I've read enough about it and been online and talked to the experts down in Pennsylvania. One of the things they flush out of the land down there is Old Norm they're talking about. Well, Norm was in the land not bothering anybody. But what NORM really stands for, it's the industry standard for naturally occurring radioactive substance. Now, do we really want to spread that on the roads, or do we want to put it on our aquifer? These people in this area, their surrounding roads have really developed. As the farmers have sold off their roadfront property, you now have households around all of these squares, in Town of Stafford being 36 square miles, and is a wonderful aquifer and a beautiful, beautiful rich farmland, which we certainly know about if you drive around this area. So my concern is for the water wells and this chemical leaching into them, because we saw on the Batavia Town Line Road what happened with their water wells with just a surface contaminant. So we really need to look at this seriously before we allow this stuff to be put. I'm calling it stuff because there's so many. There's 14 chemicals in there, and you have chemicals you can barely pronounce, let alone spell. So I'm always glad when I see that the town took action to hire people that can pronounce those words and spell, and not only that, they understand what they mean. This is where I stand, and I'd like to shut up and sit down. Thank you.
Thank you. I don't want to jump in front of everybody, but by the way, xylene, toluene, benzene, I can spell them all. Two things. I want to make sure that people know, but even more importantly, the board knows. This law is not intended and does not address the spreading of brine on roads. So I hope everybody knows that that was not part of, we actually don't do those. Paid lawyers do those. But don't think that you're getting that with this. And secondly, to this gentleman, I was wrong when I thought I was wrong. We don't need to change the definition of injection well, because injection wells are not prohibited within the definition of explicitly prohibited uses. Underground injection is what's prohibited. And underground injection is the subsurface emplacement of wastes again, including the placement by or into an injection well. So,
Just waste. Just waste.
no, I'm sorry, the kind of waste, natural gas and petroleum,
So it's not
the defined term waste.
the guy was putting a pier in, it was cement.
Right, and it wouldn't even be that, because we're not saying injection wells are illegal in this town. We're saying underground injection.
When I brought these things up, I was just thinking about
No, but I told you.
cautionary tales for you, or caution the board, because they're.
Right, I'm just explaining why we don't need to make the change. Because injection well is not what's prohibited. Underground injection is what's prohibited, and that's tied to the waste. Sorry. Yes.
My name is Vicki Southall. I was a member of the original fact-finding committee for the moratorium. I would just like to add a few statistics from a report that I have called License to Dump. The report was done by the Environmental Advocates of New York in 2015, so I don't know exactly which month, but it's very recent. People have been talking about how waste is coming into New York State from Pennsylvania. New York State does not keep any statistics on this waste, but Pennsylvania does. In other words, they have a database, and it's listed here in the sightings. They have a database where they keep track of what they're sending to New York. So here are some of the things that have come into New York already. 460,000 tons of fracking waste dumped in New York to date. 23,000 barrels of liquid fracking waste dumped in New York to date. There are 5 landfills in New York State that have accepted fracking waste from other states. These landfills do not test for radiation, or they have their meters set so low that their meters don't go off when the waste comes in, the solid waste, the drill cuttings. So in Pennsylvania, statistic is that 1,000 plus radiation alarms were triggered by fracking waste in Pennsylvania, but in New York, that statistic is 0. We've had no alarms triggered by fracking waste in Pennsylvania. I have here a map that shows where the landfills are. There's one in Niagara Falls, there's one down in Angelica. I also have a map that shows counties in blue that have accepted liquid fracking waste and or there are beneficial use determinants. They're not petitions, they're
Permits.
permits, thank you. Permits, BUD permits, that allow the fracking, or allow the spread of fracking fluid on the counties listed in blue. Genesee County is listed in blue on this map. So the waste is coming into New York. At this point, as has been stated, we can't count on the state of New York to protect us, and so we're counting on you to do that. Thank you.
Yes, back, the back of the room.
I'm a teeny tiny bit confused because and thank you, that was fabulous. Everybody getting up and speaking has been fabulous. And I've learned a lot, but I am presently confused because my jaw dropped when whoever said that this marvelous petition or changes in the law would also not cover this issue of distribution on the roads. Because for the life of me, I thought I sat here and I heard could not be spread. And I thought that if it can't be spread, it means you can't spread it on a road, not just on a piece of property. So what were the references? Where is my confusion stemming from?
I apologize for the confusion, and it's understandable, it's not you.
It's not just me?
No, by
Oh,
definition,
thank you.
if it wasn't clear, it's my bad. One of the ways that the solid waste stream is disposed of, they primarily do two things. They take it to landfills, as Vicki mentioned. The other thing they do, and this is bizarre, and people have used the L word, actually called me liar, but I'll say it again because it's absolutely true. The other thing that they do is they take this stuff and they go to farmers' land. They come to farmers who are starving to death. We've all heard about why, and nobody gets upset about the milk support. Anyway, so the drill people, the people who are paid to get rid of this stuff, go across the border and they go to farmers and they ask if they can dump this stuff on the farmer's land. And the farmers say, what is it? And these people say, well, it's not hazardous. Swear to God, it's not hazardous. And the reason they can say it's not hazardous, not because it's not poisonous, not because it's not toxic, but because this industry is exempted or accepted from basically every major federal environmental law. The Clean Air Act, the Clean Water Act, the Toxic Substances. Certainly you guys have heard of Superfund, that's CERCLA. People get up, talk about the state, the Halliburton loophole. That's nothing. That was done in 2005. That's nothing. The major, that's the Safe Drinking Water Act, but all the main laws that were, the primary laws that were passed in the 70s, every single one of them accepted one industry and one industry only, and that was the oil and gas industry. And they accepted out from the definition, if it's a Toxic Substances Act, there's a section that actually says, notwithstanding any provision hereof to the contrary, in no event shall anything generated by the oil and gas industry be toxic for purposes of hereof. Every single one says that, including the Hazardous Waste Act, all those things. So they come in, they say, swear to God, it's not hazardous, and by the way, I'll give you $50 or $100 a dump truck to let me put it on your land. And these farmers, what are they going to do? They take it. So that's the land spreading that we're talking about. But we did not cover road spreading. That's a different animal. There's all kinds of jurisdictional issues. The town doesn't have, I mean, Kevin, this is Kevin's area, not mine, but the town doesn't have any authority over county roads or state roads. It's a complicated issue.
And I understood from the reading I did that New York State DOT has banned the spreading of state roads, which does not cover county or rural roads.
I don't know anything back.
Okay.
I just know that I did not attempt to, this doesn't do it. If anybody's looking to this to keep the vine off the roads, this doesn't do it.
Okay.
And they haven't
So
stopped
that's
that state
part
road.
two.
That would be, I was behind a salt
Yeah.
truck the other day.
Pardon me?
I was behind a state DOT truck on Route 5 the other day spreading it.
Seriously?
Seriously.
Well, the other thing is
I'm fine.
brine, not all brine is created equal. Not all brine is bad. Some brine is just brine. I mean, you might not like it on your car or whatever, but not all brine is poisonous.
Well,
So the fact that you, I don't know what
Yeah, I
you
don't know what it
saw,
was, but it was liquid.
but
Well,
yeah.
and I
It was salt
understand
and
that there
water.
are
I know it was.
3 separate, that the industry, so to speak, is allowed to call it by 3 separate names, whether it's water that went down, whether it's water
Right.
that goes this way, whether it's water, and that it's all bad, but they bamboozle people because it has 3 separate names
Right.
for the
right.
same cocktail.
So what we're stopping with this law, if at some point the board decides to pass it, we're stopping them coming up to these farmers and say, I'll give you $50 to let me know.
Okay,
But this does not deal with roads.
thank you, thank you.
There was a letter from Mr. Wood.
Yeah.
And also, I'm in agreement with Les on piggybacking these accessory structures into what was supposed to be a fracking law.
We have a letter that we received today from Robert Wood, lives on 5470 Clinton Street Road. He's addressing the town board and the town of Stafford subject fracking. Due to a conflict with meetings as a vice commander, I am not in attendance to offer a suggestion about the fracking issue at your meeting. Due to technology advances, I recommend an amendment to any fracking vote that will allow the fracking issue to be reviewed annually because of technology advances. Thank you for your civic services for the town of Stafford. Sincerely, Robert C. Wood. So this is another possibility that we could consider. You know, that if we do whatever we enact here, that we review it on an annual basis.
My concern as a lawyer would be that if you put something in that is tantamount to a sunset clause, that there's at least one case, the law is wrong, but there's one case where a lower court case, the Supreme Court members of the lowest court in New York, held that a situation like that was a moratorium, and then went on to invalidate the law. So rather than take that risk, I would respectfully remind the board, there's no such thing as a permanent law in New York State. You can write into it that it will never be changed. You can say that you're going to look at it every 5 years on the sunset, but you can, as long as you call your meeting the right way, in 10 days, you could, if you passed, forget this, any law, you can repeal it tomorrow, you can repeal it in 9 months, you can look at it in a year. You don't need anything in the law to authorize or empower you to look at that anytime you want, whether it's due to a technological change or otherwise. But if you put a sunset clause in, be aware there is this one case that we think is wrong, but there's a case out there that said that that would convert it to a moratorium.
Any other comments? Yes.
So I have prepared 7 pages of comments, and I hope that people will indulge me. So first of all, I have small text. So I'm going to just begin. It's kind of an overview of what we've been doing for the last 2 or 3 years, and an overview of my thinking about what's happening here. Advocates of natural gas, and I'll just, you all remember the TV ad where the lady in the black suit comes in and she's flicking whatever it is across and showing different scenes with white background, showing that natural gas is perfect and nothing can ever happen. that is bad. So advocates of natural gas call it the bridge fuel into a clean future.
Okay, now, where is this going to fit into the scheme of things tonight?
This is going to fit into this exactly.
Okay? Go.
Thank you, thank you. Those in favor of energy production with natural gas point out that it pollutes less than oil and coal when consumed and can potentially generate far more electricity with this existing technology than all existing renewable technologies combined. They say their quantities will account for the increasing share of U.S. mix of all of the conventional, of all technologies, and the U.S. mix for the next several decades, with large unconventional shale reserves playing a key role. They say the new horizontal drilling techniques coupled with high-volume fracking have made shale gas reserves viable. But accumulating reports of contaminated groundwater near fracking sites have spurred intense scrutiny and protests threatening the future of natural gas in the U.S. As studies of the high-volume slickwater hydraulic fracking have increased, so is the body of evidence which points to underground migration of fracking fluid and methane into groundwater as a nasty culprit. There is a focus on understanding the groundwater interaction with the fracking fluid and the underground strata, as well as serious unintended migration of gases and drilling fluids into aquifers, and there may well be the potential of irreparable contamination of essential groundwater supplies. This leads me to my main point and focus, which demands a precautionary approach. This is my main point. Precautionary approach to our fracking question through preemptive action in the face of an anticipatory nuisance that would be ruining our groundwater, contaminating our aquifers.
So then,
May I
what you're
please
saying here
continue?
is you're going to have to cover all of western New York, or it isn't going to work. This migration can go for
Is this
miles.
I want this to be my time to say my thing.
Okay,
You're going to let me
I think you're off base here a little bit.
know. Okay.
I understand where you're going. I'm just, we've been here
There's
for
a
2
focus.
hours now already.
Let her talk. Yeah, it's her turn.
Okay,
Other
okay,
people have
okay.
had their turn.
2 hours as opposed to 5 years is nothing, okay?
Okay.
This is law that needs to be set.
My apologies.
Yes.
Go ahead. I'll be quiet.
This leads me to my main focus, which demands a precautionary approach. We don't want ruin. In other words, if we're not sure that we're safe, then we should err on the side of caution. On December of 2014, the state of New York announced a decision to ban fracking based on the recognition that there was no proof that fracking is safe for its residents. The implications being substantial in their minds, they stated these 3 concerns: fracking industry processes economics, public health of citizens, and public attitudes. Substantial scientific evidence was used to back the state's decision, and their decision appears to be based on something called the precautionary principle. The precautionary principle, or precautionary approach to risk management, states that if an action or a policy has suspected risk of causing harm to the public or the environment, then the burden of proof is that it's not harmful falls on those proponents of the action. That means the people that want to do this thing. The principle is used by policymakers to justify their decisions in situations where there is a possibility of harm from allowing an action, or when extensive scientific knowledge is either lacking or you can't agree on the knowledge or on the information that's coming in. To protect the public from exposure to harm, when scientific investigation has found there is a plausible risk. I think we have established that in this town. These protections can be relaxed only if further scientific findings emerge that provide sound evidence that no harm will result. aphorisms related to this concept would be simply like a pound of prevention or do no harm. So to recap the precautionary principle, if an action is suspected of causing harm to the environment or human health, then even in the absence of scientific consensus, which is what we have had in the town of Stafford, we couldn't agree with our study. The study people could not agree. In the face of overwhelming evidence, then it falls to the person or the organization or the industry, in our case the fracking industry and those involved in it, to prove the proposed action is safe. The precautionary principle with regards to fracking underlines the conflict between natural gas industry and local citizens where fracking either exists or is planned. Citizens believe that there's enough evidence to show that fracking causes irreparable damage to the environment and to health and must be banned. The gas industry and those involved in it not only reject this idea, but they also demand beyond a shadow of a doubt proof that fracking is harmful before legislation should be invoked. So far, the industry has been quite successful in creating significant exemptions from most federal, state, and local, and some local regulations. So in December of 2014, Como announced his landmark decision to ban, I mean, this is not quite how it happened, but it's kind of a ban, 3 to 5 years. And he based it on a review of scientific evidence and New York Health Commissioner's opinion, Dr. Howard Zucker. You probably know this guy. It was interpreted as an action using precautionary approach. Zucker said, I have considered all the damage and find significant questions and risks to public health, which are as yet unanswered. I think it would be reckless to proceed in New York until more authoritative research can be done. I asked myself, would I let my family live in a community with fracking? And the answer is no. I therefore cannot recommend anyone else's family to live in such a community. At the same time, they sent out 3 reports. You know, they flooded the newspapers with reports that week when they gave the decision. And further, Zucker remarks, and I'm going to be talking about the 3 reports just in a bulleted manner. Zucker further says, as a more complex human activity in modern societies, as with more complex activity in modern society, absolute scientific certainty regarding the relative contribution of positive and negative impacts on fracking on public health are unlikely to ever be obtained. And he said that in this instance, however, the overall weight of evidence from the cumulative body of all information contained in the public health reviews demonstrates that there are significant uncertainties about the kinds of adverse health outcomes that may be associated with fracking and the likelihood of occurrence of adverse health outcomes and the effectiveness of some of the migration measures in reducing or preventing environmental impacts, which could adversely affect public health. Until the science provides sufficient information to determine the level of risk to the public health from fracking to all New Yorkers, and whether the risk can adequately be managed, the Department of Health recommends that fracking should not proceed in New York State. And so they've got 3 studies that they put out there to support their findings. And the first one is from New York State Public Health. And these are the things bulleted that they said about fracking. The air impacts and the respiratory health. Climate change impacts, possibly due to volatile organic chemical releases into the atmosphere. Drinking water impacts from underground migration of methane and fracking chemicals associated with faulty well construction. Surface spills potentially resulting in soil and water contamination. Surface water contamination resulting from inadequate wastewater treatment. Earthquakes, community impacts associated with boomtown economic effects such as vehicle traffic, road damage, noise, odor complaints, demand for housing, etc. I'm not going to read it all. The second one is a report from the physicians, scientists, and engineers of New York. And they say, the main points that they say are 96% of all the papers on the health impacts indicate potential risks or adverse outcomes in health from fracking. 87% of original research studies published on health outcomes indicate potential risks or adverse health outcomes. 95% of all original research studies on air quality indicate elevated concentrations of air pollutants. 72% of the original studies, research studies on water quality indicate potential positive association and actual incidence of water contamination. There's an ongoing expansion of the number of peer-reviewed publications on the impacts of shale and tight gas development. Approximately 73% of them have been done in the last 24 months, with a current average of one paper coming out every day on the adverse effects to the environment and to human health. And that would include all health of the planet. And I'm concerned about all of them, but I'm concerned about this town. So now if we look back at these percentages and the study, the evidence is compelling. The third study is from the Concerned Health Professionals of New York, and I won't even go into that. Air pollution, water contamination, inherent engineering problems that worsen in time. I think that's the cement breaking down. Radioactive releases, occupational health and safety standards, noise pollution, light pollution, stress, earthquakes, abandoned and active natural gas wells as pathways for gas and fluid migration, threats of ag and soil quality, threats of climate system, inaccurate job claims, increased crime rates, and threats to property values and mortgages, inflated estimates of oil and gas reserves and their profitability, and serious risks to investors. I don't think we think that much about the investors in these things. In summary, the principle that states that if a practice such as fracking has suspected risk of harm to the public and to the environment, that the burden of proof is that it's not harmful falls on those promoting the practice, that the industry and that's the industry and the people involved in it. Studying the subject in depth shows anybody strong evidence of fracking, that fracking can pose inherent harm to environment and to personal health. We all know the havoc and the heartache that relates to family health and its loss. Remember where fracking waste and the byproducts end up. At this time, there is no way to contain its devastation. For the sake of our environment, our families, our husbands, our wives, our children, our grandchildren, and their progeny, I urge you to use the principle of caution and vote yes on Stafford's local law number 1 of 2015. Please add my remarks to the record. Respectfully submitted.
Thank you. Yes.
I'd like clarification regarding the accessory use that was alluded to by Lester, and maybe Mr. Slottje could answer it.
Is that all right? Yep. We addressed two things with accessory. We've used accessory buildings and accessory uses. With respect to accessory use, I think the only thing, I believe the only thing we did with respect to accessory use is to add the following sentence to the end, which says, under no circumstances shall any explicitly prohibited use qualify as an accessory use. Let me explain for people who don't deal with this stuff what accessory uses are. The general construct in New York State with respect to land use laws is that unless a particular use or category of use is explicitly allowed, well, first let me tell you what zoning is. Zoning is simply the division of a town into two or more districts. land use districts, where certain types of uses are allowed in one district and other uses, and they may overlap, are in the second district. You can have more than two, but you've got to have at least two to have zoning. So again, the construct, if you've got zoning, we do have zoning here, is that you may only, within any particular district, you can only have a use is permitted only if it's specifically articulated as allowed within that particular district. Okay? So there's something called allowed as of right, and if your particular use is articulated, specified as allowed in that district, then you can make use of that use as of right. You don't need the town board's permission, you don't need the ZBA's permission, you don't need the planning board's permission. You still need a building permit. You might need to go through subdivision approval and things like that. But with respect to the use itself, that's what we mean by as of right. There's another category of allowed use, and it's called special use. Some people call it special permit. What that is, that's basically a use that is allowed conditionally as long as the appropriate board, and in most cases it's the planning board, as long as the planning board says it's okay, and there's standards they look at. So there's as of right, because your use is specified as allowed. There's a special use, which also has to be articulated as a special use. In other words, if something is not listed as a special use, you can't use a special use to get it. But you basically say this is allowed with special use. Then there's a third category called accessory use. And accessory use basically is just something that is typically so common that the theory is that probably the people who passed your zoning code assumed that this accessory use would be okay. A common example might be a garage in a residential area. That's typically accessory. A barn in an agricultural situation. So with respect to accessory uses, which is the third area of allowed uses in this and every other town that has zoning, all we've done, I believe, with respect to the, at least substantively, all we've done with respect to the definition of accessory use is add a sentence at the end that says, under no circumstances, it's what we were talking about before. Under no circumstances can you try to shoehorn in here and say that your gas well or your waste disposal facility, whatever it is for gas waste, is accessory to something else. Does that make sense? So the same way we said, don't tell us that commercial excavation, that the gas stuff is subsumed in that or anything else. So that's what we're doing with the accessory use. There's also a concept called accessory structure or building. And we did make a change to that. I suggested the change, actually. It has nothing to do with gas. And what we were trying to do is basically save the town money if it turns into a... Most places make it clear, explicitly clear in their definition of accessory buildings or accessory structures, that the purported or supposed accessory building has to be on the same lot. They make it clear that it can't be, that it's got to be, what's the word I used here? It can't dominate the use. What you don't want is a situation where somebody's got, you know, whatever it is, they've got a house here, and it's allowed, it's a residential use, and they've got this gigantic, on some separate lot even, huge, you know, candy factory, or whatever it is that you wouldn't want in your residential neighborhood. And they say, oh, that's just accessory to my, or let's say that it's permitted in the residential district that you've got home business or home occupation is an allowed use. So these people say, well, we've got a home occupation here, which is allowed by special permit, but I'm going to have this huge thing over here that I'm going to treat as a, you know, let's say it's a warehouse, a gigantic warehouse, and they're going to say that I get to put that warehouse in. I can build a warehouse over here, and yes, I understand you can't have warehouses in a residential district, but that warehouse is accessory, that's an accessory structure for me, because I'm allowed in the residential district to have a home occupation. So what we've done, which brings your code, if it's adopted, into conformity with There are 900 some towns in New York State. I haven't looked at the zoning codes of all of them. I've looked at the zoning codes of probably 400 of them and worked on probably half of those at this point. And I can tell you that 90% of the 400 I've looked at make it clear, as what I'm trying to do here, that if you want to have an accessory, that in order to qualify as an accessory structure or an accessory building, it's got to be subservient. It can't somehow be bigger and dominate what is supposed to be the primary use. And, because this happens in litigation all the time, we also make it clear that it's got to be on the same lot and that that lot's got to be in common ownership. That's what you find in, I haven't looked at all 900, but that's what you'll find in 90% of the 400 New York State codes that I've looked at. And that's protective of the town. That's so that somebody can't come in here and say, yeah, I don't own the lot, it's not even the same lot, it's 10 times as big as my house, but I'm going to put a warehouse in here and say that it's accessory to my little home occupation. And by the way, I'm going to make these guys pay Kevin Earl to defend it on it. So it's not, it has nothing to do with gas issue. I happen to be here, I had the car up on the jack, the hood was open. It's not costing them anything, you know, so I tightened some bolts, or suggested tightening some bolts. This is one, on the accessory structure, it's just a bolt tightening. It has nothing to do with gas drilling. It goes to them if you like it or if you don't like it, but that's why I did it. With respect to accessory use, that is a gas drilling issue, and that's why I said do whatever you want with your accessory use, but don't try to come in here and say that your dump for waste, gas waste is somehow accessory. So that's what's behind that.
Yes.
My name's Chris Kurtanik. I'm from the town of Bethany. And the reason I'm here and very concerned with what is occurring here today, because even though you think it doesn't affect Western New York, it truly does, because very few townships have even taken on to do what you've done. I commend you for even acting on it. But you're kind of setting a precedent for other towns, especially Genesee County, moving forward. So I'm trying to get some ideas what you're doing here. Initially, as the attorneys were speaking, what you've laid out here, I thought has some pretty good teeth to it. But then on the other hand, I'm hearing from the gentleman here from your planning board too, concern, and then the letter from Mr. Wood. Before you've even initiated, what I thought had teeth is starting to sound like bad dentures maybe. That can be easily taken out. So as our attorney said here, if you move it into a year where you're looking at every year, you're weakening it, definitely going to weaken it. You're opening yourselves up. That's my feeling, just from what I'm hearing. Then if you are going to take the teeth out of it and open up for review, then I have to ask myself, is there something already in the works that other people are already projecting for future business, whatever, that you're worried about interrupting those plans already? Yeah, so I'm already thinking, is there an objective for not enforcing it long term? That's my concern. And I'm using the same concern when I take it to my town, because we're in a transition place now. New town supervisor, he's just getting his bearing with the town budget, let alone the scope of something like this. So I try to bring to the table in a good way what's going on here, and hopefully you look at it as well too. You are not just protecting your town, and as the lady said here, it goes way beyond our town, because it can be a domino effect, and towns will tend to follow suit. So what you're doing here initially, I think is very good, and I hope you follow forward with your original law amendment.
You talk about the domino effect, that was what I was trying to explain, not contradicting what you said, but you know, what goes in the ground can be 20, 30 miles away, can affect that ear. I mean, we can
add to it. Let's not add to it. That's the idea.
Well,
you know, then you get into acceptable level mindset, you know, and it's, well, we are concerned about, this is what we're talking about here right now. And I'm saying you are setting a precedent for what you're discussing right here. People are going to look at. I am one of them. Moving forward, hopefully build on the best that you have, so where there's a solidarity of mindset to protect our soil, our water, our general health, emissions, what's coming into our
that was what the original intent was when we first started, was have a section of our zoning law that dealt with the fracking and the disposal of the materials generated by gas drilling. That was the first thing. It has kind of morphed into something a lot more than that. And I think that's what Mr. Mullen was alluding to here. Yes?
I have 2 points. One is about what Lester said and what the attorney here just said. I think a lot of people have a house, maybe 1,200 square foot house, and they might want to build a 3,000 square foot barn. And I think it's happened a lot to probably a lot of people in this place, and I know several. And the way he was describing that law, I don't think you'd be able to do that, so I'd recommend against putting that part in. You know, because I mean, if a guy wants to have a little shop in his backyard to work on his hot rod or something, it might be bigger than his house. Okay, and the way he's talking, it can't be. Second thing is, and this is just something that just came to mind, there are some natural gas cars that are being sold around the country, and I know in Monroe County, they've got a fuel station, I think, and it won't be long before there's going to be individual fuel stations that are going to be available for sale, I'm sure, at some point in time. And would any law that you're passing prohibit those? Okay. I mean, I don't think anybody's got any. I don't think they're out here, but I remember there used to be a guy over on Transit Road years ago that had a propane car, didn't he, John?
Yep.
What was that? Lived there where Jerry Mancuso lives, and he had a propane fire car. That was probably 25 years ago. But you know, it might come down the pipe. I don't know if is there anything in this law that says a guy can't put a if they come up with a new type of a fueling station, individual that you can hook into your gas lines, because I mean, a lot of people that are against the gas probably have gas lines here. But,
The only thing, this doesn't stop methane digesters, it doesn't stop propane cars, it doesn't stop putting propane in your...
how about natural gas cars?
It doesn't stop putting propane in your barbecue, it doesn't stop using natural gas for anything. You can put natural gas in anything place you want. This doesn't address that at all. And therefore it doesn't prohibit it. It doesn't allow it, it doesn't prohibit it. It doesn't touch it. It's like saying, what does this do to my Irish setter? This doesn't pick up Irish setters, it doesn't pick up methane digesters, it doesn't pick up natural gas cars, it doesn't pick up fueling stations.
If these guys wanted to hook their cars into their gas well, they could do that.
Who's got a gas well? Is it legal?
Yeah. Good. Okay. I mean, it would be restricted if they couldn't, I thought.
I mean, are you suggesting that there's any possible reading?
I'm just
that's
asking
the
the
case?
question
No.
for the future.
This prohibits,
That's
basically,
a compressor.
this prohibits
See, that's a
7,
compressor station, because you'd have to compress the natural gas. If John wanted to hook his pickup truck up to a natural gas, he has to compress it, I think. I don't know.
Yep.
I think.
the only type of compression facility that this doesn't stop air compressors, it stops a facility constructed or operated to raise the pressure of natural gas in connection with its extraction, processing, or storage, or its delivery into or out of the transmission pipeline system. So it has nothing to do with what the individual user does. And there's no room to suggest what it does.
Good. I had to ask.
So this actually does nothing with our gas law?
Because it's illegal.
Because it's legal, it does absolutely nothing?
We are grandfathering.
You're grandfathering, but you're stopping fracking, and that's the whole idea behind this. We're not drilling a well, it's been there for 45 years.
So as long as you don't expand it, you're good to go.
So I can't add another house to my
Nope.
gas well?
No.
Okay, what's that got to do with fracking?
The law in New York State says that we are not allowed to, actually this says as long as it's, well yeah, you wouldn't be able to do it. New York State law is that we cannot permissibly make a distinction between conventional wells and unconventional wells. That if we do that, if we make a distinction and say conventional wells are okay, unconventional wells are not, we are regulating the industry because we're dealing with operations and processes, and there are court decisions that say that that if you were dealing with operations and processes, and fracking is a process, or conventional versus unconventional is a process, that we're regulating the industry. There's a state statute, doesn't matter what it is, it's Environmental Conservation Law 23-0303 subsection 2, and it says that notwithstanding anything else that we know about police power or anything else, that a town may not, a local government may not pass a law to regulate the industry. If we pass a law that doesn't cover all gas drilling, in other words, we make a distinction between conventional and unconventional, even though it's unconventional that people are worried about most of the time, we run afoul of that prescription, and our law gets thrown out.
I have no problems with, I'm not looking to drill. So there's no drilling involved with it.
Yeah.
So therefore, I have an existing well, and I add a pipeline to it. There's nothing drilling with that. Now, I'm not fracking, it's not conventional, it's not unconventional, or whatever. Why is that?
Do you have you don't need a permit for that?
Probably do. I'm not looking to do it. I'm just asking because it seems like you're telling me I can't do anything more with my well, even though it's existing. I'm not drilling, I'm not fracking. This whole thing was to be against fracking. I'm not putting away waste.
This board, what's being driven here is your pre-existing well. These changes were your pre-existing well. The other changes were not changes, saying that, we weren't. So if the board determines that they would rather take care of your one existing well so that we're already saying you're fine, good to go, but that this doesn't work in case you want to continue to enhance your nonconformity, which, as I've said before, is black letter law against the public policy of New York State, then tell me now. I got a plane to catch at 4 in the morning tomorrow, and I'm 2 hours away from here, 2.5 hours, and I'll leave. But that's what it comes down to. You got one well that's grandfathered. They've already changed it so that, unlike what the first draft was, that it had to be legal, it doesn't, maybe it is, maybe it isn't. We've already grandfathered that. And if you are asking them, don't ask me, ask them, if you're asking them to blow this up so that your one well, you can continue to enhance your nonconformity when you just said you don't have any plans to do that, there's no way to split this baby. We can't carve you out.
Well, my whole thing was, I thought this was all supposed to be, there's no fracking, there's going to be no drilling.
That's what this is about.
What did that have to do with?
That's what this is about.
Pre-existing things as well.
That's what this is about. And because of New York State law, which nobody likes, the pro-gas people don't like it, the anti-gas people, but because of the state statute, unlike that December 17th thing, which is not a statute, a state statute says we can't regulate the industry. Court decisions, including the Court of Appeals, the highest court, says that if we make a distinction between conventional and unconventional, we're going to be regulating the industry. So the only way that this town or any of the other 200 towns that wanted to do this can do it correctly is to prohibit all of them. They are grandfathering you. They went beyond anything I've done in 200 towns by taking out the legal part. They're grandfathering you whether you're legal or not. My guess is if you're sending this off to more than your own self, you probably are not. I don't want to get into that, but you're probably not legal. But to ask them to go beyond that and to say not only are you grandfathered, but you can expand that nonconformity without a permit.
Well, as soon as you own the crack, they can drive on the track through it.
Right.
So, that's basically what he's saying. If they make an exception for a small little grandfathering expansion to be okay, some enterprising attorney will drive a Mack truck through that exception.
Right.
Go ahead.
I just want to speak, not on their behalf, but just as a neighbor. Her father and her uncles had that well drilled 30 years ago, and they haven't bothered anybody. And if they want to build another house or add something to it, this guy's pretty accusatory to them. It sounds like Ron might be thinking he might want to do something. They've lived there their whole lives. They haven't bothered anybody. And Johnny and Shelley might want to have a retirement home. You don't know. I mean,
I'm not accusing anybody of anything, but what I'll tell you is about I lived in this town.
I was almost.
I understand.
Go ahead.
But you're talking about me and use the word accusatory.
Seemed
If
like
I lived in this town,
Seemed like it to me.
if I lived in this town, and they expanded, I don't care if it's been 40 years, and they expanded, and they sent it to one other of their friends, and put a, quote, pipeline in, which probably also, and they did that without a permit, And then maybe they've been lucky for the 30 or 40, the next time somebody blows up and dies, not only am I going after them, I'm going after them because they carved out something in their law knowing that they had, let's call a spade, an illegal well.
I don't think it is, I think it was.
You don't think it is?
It's all.
I think it was illegally, I think the pipeline was installed by a
It's all in
pipeline.
the book.
It was all installed by a pipeline contractor, wasn't it, Johnny?
That has nothing to do with it.
Well, yeah, it does.
Well, no, it doesn't. Sorry, I've been practicing law for 30-some years. It
You're
has
right.
nothing to do with whether a pipeline contractor installed it or not, if they didn't have the right permits. The fact that they found somebody to install it doesn't have anything to do with the price of tea in China.
Johnny,
The
did they have a
pipeline
permit?
drilled it and they said it wouldn't produce enough for what they wanted, so they sold it to our farm for $1.
Right, and have you expanded it since?
No.
So what I'm talking about, what I'm talking about
Test
is,
the well.
what I'm talking about is a subsequent expansion. And even if it didn't need a permit, in your hypothetical, you're talking, what if I do this in the future for another house? So I promise you to do that in the future would require a permit. In your hypothetical, you wouldn't get the permit. You didn't get the permit, rather. That's illegal.
Okay.
And if you're asking them to make that legal, to grandfather, then you should call, ask them.
Well, it wasn't.
But they need to understand what you're asking. They've given you more than I've seen any town give right now, by taking the words legal out.
It is legal, but that's okay. I just should probably get word.
Okay.
I'm talking about the extension.
As far as I know, that was all done legally also.
Well, then, there's no problem.
Yeah, there were 3 farmers that just asked if they could do it, as far as I know, the town did everything.
But the notion that some pipeline company or some contractor did it, it doesn't make it legal and it doesn't even make it done well. No pun intended with well. Doesn't make it done right.
I think you hit on a good point that we cannot do carve-outs.
No, I just,
And, as careful as we've tried to be with everybody's former non-conforming use and all that, we can't go any farther than what we are, or else we start going contrary to what the state wants us to do. Phyllis, you kind of stole my question. We had a couple of points raised on the accessory use. And our current code says customarily incidental and subordinate. And the new one says that you're not allowed to dominate in area, extent, or purpose, which probably refines that a little bit better. I guess let's
Refine subordinate.
Yeah.
You're right.
So I guess I'd have to ask, since both of our building code people asked that question, do we see any problems coming up in enforcement caused by a difference in the wording of the law, which simply, to me, defines what customarily incidental means and subordinate?
No, I think, all I'm thinking is if a person builds a 1,200-foot square house, then you can't put a building on there that is over 1,200 square feet. That's just an example.
You got a lot of pole barns that are bigger
You
than
have a
that
lot of
residential
people that
area.
want, I mean, if I own 6 acres, all one plot, and I put a house up there, I'm not talking to you, I'm talking to my board, and I want to put a building up there that is 1,400 square feet, can't do it.
What's the underlying zoning say, even though you're talking to the board? Because if you're talking in almost every other district except the residential, you'd be able to do that as of right anyway. This issue only comes up in a district where you're dealing with, where you're not able to put that barn up to begin with under your underlying zoning. So it wouldn't come up in, say, an ag district. It probably wouldn't come up in an industrial district. But you can't look at this in a vacuum. You have to look at it in what district you're talking about.
Residential.
So in the residential, yeah, you have, depending on what the acreage.
I think there's quite a few barns here that were built bigger than their houses in the last 4 years.
District though, right?
In a residential, yeah. I can think of 3 right here.
It would be no problem, board, to delete the change As I said before, it has nothing to do with gas drilling. To delete the change, the suggested change to accessory building structure. And instead of so just leave that the way it is, whatever it says. And with respect to accessory use, instead of trying to tighten up what subordinate or dominant means, which we've done, strike that and just add the one sentence that's in here to the whatever accessory use says now, we leave it, but we add the sentence that says, under no circumstances shall any explicitly prohibited use qualify as an accessory use. I'm happy to do that. I can get that to you tonight before I leave tonight. If that's what
But to answer you, Ron, would it, no, because if it's in here, if it's in the book, then it's up to us to enforce it. That's the bottom line. No, it's not going to make a difference to Gene and I as far as that part.
No, I'm just looking for the examples of what would come under enforcement under this wording versus the old wording, is what I was looking for.
Well, you have to take a closer look at it, comparing it to the two.
If you build a 3-car garage, you're going to be past the 12 or 1,500 square feet of the house.
So it's primarily use and area. The use that dominates the principal, use and area, extent or purpose.
Yeah, we're not so much concerned on the use, we're concerned mostly on the size. It's not a permitted use that they're going to build a building for, it's not a permitted use, period.
Maybe we ought to go back to square one here and concentrate on the original idea that came out that deals with fracking and the disposal of the material that fracking causes. Why don't we just deal with that and leave everything else out of it for now?
It's two easy changes. We don't make any changes to accessory building structure, and we add one sentence to the existing definition of accessory use, whatever it may be, to just make it clear that under no circumstances can explicitly prohibit use qualify as an accessory use. That's it. And then everything else is gas drilling.
What do you think about that?
Well, get it written and let's get a chance to look at it, when it comes out in a week or two, right?
All right.
Let's
Thought it was up
delay
to
some
town
more.
board.
What's that?
Let's delay some more. This has been going on for 3 years. There's been intentional dragging and delaying. And
Changes
everybody
came
is
tonight.
It's time to get this done.
These changes can be done right now. They're deletions. They are deletions. It's a cross out. That's it.
I got one question. Lester, don't we say in the zoning ordinance an accessory building can only be 1/4, the use can only be 1/4 the total square foot of the house?
That's for
The main
home
structure?
occupation.
Was that home occupation? Home occupation's that way? Okay. I knew it was.
It's in there.
Well, I guess
Any suggestions that I've made here is not to delay this. That's not, it's not a delay tactic.
no, this should have never been brought in with what we're doing. We were gonna go for ban the fracking. There's signs all over town that tell us, and we don't even know who put them up. And then you go to the fact that, you ban the fracking and then you wanna go to the dumping. I can understand that. I can understand the ban the fracking. Totally I can. I don't want the wells polluted. I got kids, grandkids, and who knows what, and I've been a lifelong time here. And as far as dumping the waste, I agree with it. But why are we piggybacking in another law on top of the same thing we got?
While he had the thing open, he was looking, he thought there was something that would help us. I don't really think it was meant to tag anything on or hide anything in, but he seems to know zoning upside down, inside out, better than probably all of us combined in this room, and he thought it was something that would help us.
Nobody can come in the back door.
I like the idea of tightening things up. If it doesn't work for us, we can back off a little bit, but.
Yes?
He did make the comment that nothing was going to change at the very beginning of his speech. That he wasn't changing any of the present zoning unless it was specifically for natural gas exploration and fracking. I don't think that one has anything to do with fracking, does it?
Accessory use change does. The accessory building one does not.
So it seems like there's a little bit too much going on here.
Well, that was all talked about at the work session 2 weeks ago. He explained what he done. We went through all this that day.
And that's
So-
good, Bob. I mean, don't get me wrong,
Right.
I'll go with whatever the board's decision is. I just threw that out there, and that's what I feel. That's fine. I have no hard feelings of it. It's just, you know, whatever it is, it is.
Yes. And then personally, we just want to keep doing business, what we're doing.
Well, I understand that.
We just want to keep doing our business.
There's not one of us up here that wants to hurt your business or any other business in town.
The comment that he made, are you intending to grow? If we intend to grow, that's our business, not somebody else's. We don't
Go
intend
into business to grow.
Yeah.
Why would you go backwards?
Yeah, so we might want to grow, we might not. I mean, I'm getting pretty old, but, you know, it's a
We're all
little.
getting older sitting here.
It's a little.
Getting older, listen to this.
But it is complex, given your zoning, because again, we're not, as I said earlier, we can't cut out anything special for you. And if you're not within your zoning, you are restricted based on the state. If we go any farther in giving you freedom to expand, we could be open for litigation from the other side. So
That putt, or whatever you called it, if you had 5 or more acres, you can make it a different zoning, is that the idea? So that could go, if we ever wanted to do something, we could do that. Change the zoning.
So if you have 100 acres, you got a lot of putts, right? Put it all in
you have to get them all approved first, but
Yeah, but you can do it.
Well, you gotta go through the planning board. You
Yeah.
can't just do it.
Right, but you got the potential to do it.
I don't think that, you know, lots of businesses around haven't bothered anybody, you know, they've just been going about their business and not bothering anybody. And that's, our biggest concern was, can we keep operating the way we are without restrictions? And, you know, right now. Is this law going to restrict us in any way?
Now, that's stupid cats will up there.
Don't intend it.
There you go.
no more than you're already restricted.
Right.
What was that?
Or store brine.
I might store brine.
What?
I might store brine,
Why?
but it won't be gas well brine,
There you go.
okay?
Okay, so then it doesn't affect you.
Can I just talk to her? She asked a question of clarification earlier, and there's something called brine, but it doesn't come from gas wells, it comes from brine wells. Okay, and all the towns and all the states and all the counties use it in addition to rock salt, you know the salt that goes on the roads?
Oh, yes. I
Okay,
understand.
they augment it with liquid salt brine.
And
Okay.
where does that
It
come
comes
from?
from a brine well, okay, not again, there's no gas. It's-
Tell her about the one in Colorado. That's where I hauled it out and filled every state tank
Yeah.
around here.
There was one there in Colorado, there's 2 in Wyoming County. They've been there for 40 years.
But you're not talking about
No,
the
nothing to do with it.
the
Nothing to do
carcinogen
with
stuff. Thank you.
I'm sorry. There's something-
Okay. If there's nothing further in the public hearing, we'll close the public hearing at 10:14. Now. Yeah, let's take a 5-minute break and we'll proceed on from here. Okay, the next 3 items on our agenda have to deal with the hydrofracking issue. Based on advice from our attorney, he would suggest that we do not go further on this tonight. We will rewrite this.
I'm of the opinion that when you advertise a local law, obviously it's in the format that we had, and there's been some very concerned people here that have been following it and did not have these latest revisions. In addition, the reason you have a public hearing is to hear from the public. So if they went ahead and ran through the law without taking into account some of the public's comments, I think you'd be pretty unhappy. I know a lot of people don't want to delay it again, but I think the prudent course here, because we want to pass a law that will stand. If you made revisions to the law from what was advertised, even though You might argue they're not, you know, substantial, but again, do we want to be in court arguing that? I think we are going to delete the accessory use for one of the comments that was made, and some of the other comments that were made at the work session by the planning board and in the town board. I think the planning board hasn't even, all of them probably haven't had a chance to see if the revisions that were proposed are the ones that they wanted. So my recommendation is that we make the changes based on what we heard at the public hearing and from the work session. I'll redraft that. Mr. Slottje will present me with the redraft. We will then have to advertise that law as the one that the town will consider. Obviously, I don't think we have to go through all of the, you know, all of the comments that were made at this public hearing. Certainly can apply.
Will that have to go back to the county and planning?
We have to go back to the county, and we have to go back to the town planning board, because we've made, you know, what I would argue are substantial changes to what everybody looked at, and I think everybody should have the right to look at it before the town board passes it. So I think if they try to go ahead and scratch that out and add this, scratch that, without everybody knowing exactly what they're scratching out and adding, would not be the best way to go. So I'm recommending that the board not act tonight, and we'll have to have a redraft of the local law in its form. We'll have to advertise it, go back to the county, the town planning. You know, it's going to delay probably about 2 months, but you know, it's about 2 months. I mean, we got to have enough time to get it done. We got to have enough time to get it to the county planning board and get it back. So I would say we will have to have another public hearing. But again, I think everybody's comments that we've heard tonight certainly would apply. You know, there's not going to be so substantial a change that I think people are going to want to, you know, anybody that's in favor of it is certainly going to be in favor with these changes. We think all these changes are for the better. So about 2 months. But that's my recommendation.
Yes.
Could I ask, what happens to the moratorium if we have this lapse of the moratorium because it runs out?
Technically, I guess somebody could come in and try and hydrofrack in the short time period that there's not going to be a moratorium. We don't have any time to pass a new moratorium. That would take just as long as passing the law. We'd have to advertise it.
But we're all of the same mind that we're going forward with this, and we're not going to drop it because the moratorium is dropped.
No. I think it's pretty clear that everybody here is in favor, and I think the board heard that loud and clear. But I think when the changes were made, like I say, I've been in public hearings when people make comments and then the board goes in and votes on it. And, you know, you go, what? You know, did anybody listen to our comments? You know, that's the reason you have a public hearing, and sometimes this happens. You know, you have a public hearing, and somebody goes, whoa, yeah, that accessory use, you're right, that's a good idea, let's change that. You know, and if they didn't change that, I think you might be, you know, why did we come to the public hearing if somebody made some good comments?
And they still want
So-
to change it. I mean, you know.
Okay, so just table.
Well, I don't even know if we table it, I guess I would just say, just don't take any action on it. Yeah, nobody, what I drew up for you was a resolution to approve the local law as it was previously done. So if nobody offers the resolution, we're done tonight.
Let the record show that the town board took no action on this matter at this time pursuant to advice from our attorney.
Yeah, that's accurate.
Okay. This is not the end of the road.
Yeah, it is.
Huh?
Yeah, it is.
All right. That's it.
Thank you. Union contract status.
Did you do the?
Oh, yeah. Oh, I'm so sorry. Let's start at the top. All right, thanks. You're gonna miss out on my fun stuff. Okay, let's have the approval of the minutes of the February 9th, 2015 regular town board. Second. Motion approved by Councilman Pacer, second by Councilman Tice. All in favor, say aye. Aye. Opposed? Carried. Motion to approve the financial. So moved. Motion by Councilman Pacer, second by Councilman Victory. All in favor, say aye. Aye. Opposed? carried. Old business 1 through 3. This goes back to what I just told you, that the board took no action pursuant to the advice of our attorney. Okay, union contract status. Now we're back.
I just got whatever you just gave me. We're coming out here the 20th to talk about a personnel issue anyway, so
Yeah.
I will have a copy signed on the 20th, regardless, and I can type the whole thing over myself.
Before we get to new business, I will publicly, in front of, well, a lot of people have left here. Sandy Swanson was very unhappy with my comments to her, and I will publicly apologize. I meant no, it was nothing personal. The meeting was kind of going along, and while I agreed with some of what you, or maybe all of what you said, but like I say, I had no intention of, you know, including you out of this. So you have my public apology.
And you have my public acceptance, and I understand. I understand very well. It won't happen again, I know.
It won't. New business. Renee Price might have been here.
I don't see her.
I didn't see her.
I don't know if she,
I didn't see her.
anyway, we'll invite her to the April meeting, and she'll give us a rundown on the progress of the youth recreation at this time. We have Town Planning Board suggested the appointment of Lindsay Yoder to fill the vacancy. Dear Town Board members, as you are aware, town advertised for applicants to fill a currently vacant position on the Town Board, on the Town Planning Board. 4 applicants responded to the town clerk with an interest, and all 4 candidates were interviewed by the remaining board members at our meeting on February 25th, 2015. Candidates included Thomas Stefanello, Lindsay Yoder, Ron Totten, and Bonnie Roth-Kinney. The current board was very impressed with the qualifications and integrity of all 4 of the candidates, and felt from the responses they gave to our questions that all were very well qualified for the position on the board. 2 candidates did stand out in our opinion, however, based on their backgrounds, education, and experience, and it was a difficult choice as to which person to recommend for appointment to the town board, by the town board. We felt that both Tom Stefanella and Lindsay Yoder were extremely well qualified for the position, and either would be a definite asset to the planning board and to the town. After much discussion, it was agreed by the planning board members present at the meeting to recommend that the town board appoint Lindsay Yoder to the vacant position on the planning board. Of course, the final decision is up to the town board, and we would be happy to work with whoever the town selects. It was also suggested that the town may want to consider establishing an alternate position on the planning board. If the town board agrees with our recommendations and an alternate position is created, we would recommend that Tom Stefanella be appointed to fill that position if he is interested. Once an appointment is made, please have the town clerk contact all of the applicants to make them aware of the final selection. We anticipate that our new member would attend the March 25th Planning Board meeting. Please call me if you have any questions. Very truly yours, William R. Van Alst.
Thought we already had an alternate.
The alternate was for the Zoning Board of Appeals.
You're right.
There might be a special
We
procedure
saw
for
her recommending her for the planning board. The idea was that, or the thought was that basically the planning board felt that both Lindsay and Tom were excellent candidates, and we'd like to see all the candidates were exceptional. But we thought those 2 stood out, and we'd like to see if we could figure out a way to get both of them involved in town government somehow.
Well, we can do that, Tom.
We definitely we did take a vote, and on the basis of that vote, we recommended Lindsay for appointment to the planning board. Discussion came up with the idea that the zoning board had an alternate member, and we thought, well, you know, is that something that the town might want to consider for the planning board as well. And if that was the case, then, you know, one way maybe to keep Tom involved would be to see if he would be interested in being appointed as an alternate for the planning board.
So we can do this in two separate motions.
Move that Lindsay be appointed to the planning board.
Second, establish the alternate.
Okay.
And then this is for to approve Lindsay. So you make a-
Okay.
Who made the?
I made the motion.
Vickery, Pacer. Motion by Councilman Vickery, second by Councilman Pacer to appoint Lindsay Yoder to the vacant planning board position. All in favor say aye. Aye. Opposed? Carried. As it is, town clerk wrote it here, a motion was then made by board member in a blank and seconded by board member to establish an alternate planning board position and appoint Tom Stefanella as an alternate member of the town planning board at a salary rate of $25 per meeting. Motion by
Second.
Pacer, second by Vickery. All in favor say aye. Aye. Opposed? Carried.
Are they going to need an alternate for the ZBA now?
Yes.
Okay. Because I think Lizzie was the alternate.
Yeah. Well, we can advertise for that.
Yeah, you'll have to. Do we still have the names of the other 4 people that applied for that planning board position? The other 2 people?
Yeah.
Maybe one of those might be interested in the alternate for that zoning board of appeals.
No problem.
Talk to him.
Next item is the fire department member approval. At our February meeting of the Stafford Fire Department, the following individuals were approved as members of the Stafford Fire Department. Randall Henning, Batavia, New York, active member. Kelly Ekdahl, secretary. Motion for approval of this person to the fire department.
So moved.
Second.
Motion by Councilman Matthijs, second by Councilman Vickery to approve Randall Henning's active member of the fire department. All in favor say aye. Aye. Opposed? Carried. GAM meeting. Minutes and report from February 19th. Who went?
I was way too involved to get into it this hour, but the county's getting together, and if we can show on paper how we plan to save money in our budget, we don't actually have to do it. We can get a little tax reimbursement back for the constituents in the amount of like $30. But it's put on an hour-and-a-half presentation about it's the land of make-believe, the government trying to show how you could. Now, we could do this to save money. Well, we didn't get to it.
Government.
It's a shell game. It's Albany shell game.
One level of government takes too much money, and then along the
Now, we
line.
have to figure out how to save money to give to them.
Yeah, but then they're gonna give it back to us to show us what good guys they are.
Exactly.
So it comes from Albany?
It's an all
It's supposed to be done on a county thing to start with, isn't it, Barry?
Well, it's,
The
yeah,
county
we
plan.
can do it on our own, or we can go in with the county, and
We have to have some
I don't
paperwork
have to-
submitted.
I don't have the paperwork with me, it's in the briefcase, but it doesn't sound realistic.
Is there a deadline?
Yeah.
Yeah, it's just in the planning stages, it's just getting started, so.
Next meeting is March 19th, Village of Oakfield.
I have a conflict on that day. Can I switch with someone?
I'll go.
You're next.
Thanks, I'll go. Yeah, I was intending to go anyway. Yep, no problem. Any further business that needs to come before the board?
I just wanted to say that we got a new defibrillator for the town hall, thanks to Bob Matthijs. He brought it, got it through the fire department. I think it was earmarked for the rec program, but we wound up getting it here. So thanks to Bob for taking care of that.
It's not through the fire department, it's through Genesee Urgent Care.
Thanks, Bob.
Now, we're gonna get some training on that, or don't we need it?
That's a public access one.
Is it?
Yeah,
Okay.
pretty simple.
The same as one, it's exactly the same as one that was there. If he hadn't told you, you wouldn't know it was the same unit. It's the same exact unit.
Okay, who has, we'll pay the bills and go home.
Okay, I've already forgotten where I'm at here. Let's make a motion to pay prepaid general fund abstract 2, $53,173.95. The big chunk of that is for insurance for the year.
Second.
Motion by Councilman Matthijs, second by Councilman Vickery to pay prepay abstract number 2. All in favor say aye. Aye. Opposed? Carried.
I make a motion to pay highway prepay abstract 2 for $862.46 for MVP health care.
Second.
Motion by Councilman Matthijs, second by Councilman Vickery to pay highway prepay number 2. All in favor say aye. Aye. Opposed? Carried.
Make a motion to pay general vouchers abstract 3 totaling $12,729.49.
Second.
Motion by Councilman Matthijs, second by Councilman Vickery to pay general abstract number 3. All in favor say aye. Aye. Opposed? Carried.
Okay, I make a motion that we pay highway abstract number 3 for $40,389.24. The majority being $21,000 for road salt and $11,000 for fuel.
Second.
Motion by Councilman Panic, second by Councilman Pacer to pay highway abstract number 3. All in favor say aye. Aye. Opposed? Carried.
I make a motion that we pay water fund abstract number 1 for $897.
Second.
Motion by Councilman Panic, second by Councilman Vickery to pay water fund abstract number 1 for $897. All in favor say aye. Aye. Opposed? Carried. Motion to adjourn. 10:40. All in favor say aye. Aye. Opposed? Carried.
Just what I'm about to have my filibuster, take this past midnight. Damn.